as much, but we welcome you anyway. And so that's just by way of warning. We would ask you all to, whilst we enter the presentations, to turn your cameras and microphones off. We can do this for you if you can't figure that out, because that just simply helps with the bandwidth on Zoom and ensures that we have a smoother technical experience. We've had a number of technical glitches, and we're now quite expert at resolving in the middle. So if we do have a technical glitch, please do bear with us. If you would like to ask questions, the method we use is, can you type your questions into the chat field, the chat log at the side, and preface your question, start your question with, in capital letters, the word question, so that we can pick it out from in and amongst any other chat that's going on. And then as chair, I'll choose the questions we have time for and ask you to unmute, and if you feel happy to do so, turn your camera on so that you can ask a question in person to the speakers. So to ask questions, please first put them in the chat log, and that's where we'll be looking for your questions. And you can place them there at any time during the talks, and rather than simply waiting to the end, if that suits you. My only other note for the moment is that we have a social space, an after party, if you will. And again, we'll talk about more of that at the end. So if you are able to join us beyond 12 noon UK time for a bit of a chatter to others in groups of 2 or 3, and you can wander around and join different groups at will in our social space, you're more than welcome to join us there. Okay, so I think we are pretty close to being on time. So I think we should now queue up our first speaker, who's Martha Compter from the Netherlands Institute for the Study of Crime and Law Enforcement. Martha's going to share her own slides and speak to us. So if Martha, you want to start getting set up, then we'll be starting pretty much bang on time.
Okay, is this clear? So can everybody?
Yes, we can see you clearly.
Okay. Well, hello everybody. I think this is a bit weird, but I'll pretend it's normal. This is I first start with showing my the materials I will discuss. These police recordings are from quite minor street crime, and I also sometimes refer to a survey that we did on the NSCR among police detectives, and we asked them how they wrote their police reports, what questions they asked, and etc. Things like that. I'll start with a quote from Kate. She compared police transcripts with physical evidence, and she noticed that there's a high level of preservation that must be applied to physical evidence in order to avoid any contamination. And she concluded that there appears to be no concern for the embedding of contamination into the processing of interview data. Well, this was quite an eye-opener for me, because I'd never thought about police interrogations as, well, this source of contamination of the evidence. But of course, she is right. And so I will address the question, what are the circumstances that could contribute to this contamination? Well, and textualization is a central concept here, so I'll elaborate on that. And the most popular quote about entextualization is this by Bauman and Briggs: the process of rendering discourse extractable, of making a stretch of linguistic production into a unit, a text that can be lifted out of its interactional setting. And in our context, it will mean that when a police report is made, when it is printed out and then distributed amongst the legal practitioners that will deal with the case. And a specification of this is by Blommaert, that he says that entextualization involves de- and recontextualization, and decontextualization is the extraction of text from its original context of production, so writing, typing up the police report and distributing it to the legal practitioners. And then recontextualization, then it's quoted in a new setting in the courtroom as by way of quoting and summarizing or so, as a piece of evidence. Well, I started thinking about this in detail, and I realized that there were more steps in the entextualization process. So I identified different kinds of de- and recontextualizations. First of all, from talk to text, that's done in the police interrogation, then from text to piece of evidence. The report of the suspect statement is not, or a police report is not just a report of the suspect statement, but it's embedded in other texts which make it into a piece of evidence and which makes it legal and official, an official document. Then this document is included in the case file with a lot of other documents that make up the case. And finally, it ends up in court to be discussed by the judge and the lawyers. And as context affects meaning, it can be assumed that in every step of these de- and recontextualizations, that every step involves changes of meaning, which could be a case or a source of contamination. No, because we are talking about transcription today, I shall focus on the first two steps, from talk to text and from text to piece of evidence. So I start with from talk to text, what happens. And I shall address two items: the process and the substance of making up a police report. And the process, in the Netherlands, the police report is written down in the course of the interrogation. So somehow the talk and the typing have to be coordinated. And this depends on the number of interrogators, because when there's only one interrogator, he or she does the talking himself, which means that there are spaces of stretches of talk and then stretches of typing. And it also depends on the degree of adversarialness, because typing and conflict are not very compatible. When there's conflict, the typing would distract from the intensity of the situation. There's eye contact is difficult, and also interrogators tend to start typing after the suspect has given a recordable answer, which it also means that when an interrogator types up the answer, it can be seen by the suspect as an acceptance of the answer. So, interrogators tend to stop typing when there is conflict in the interrogation. Well, about the suspect, the substance of the interrogations, I'm going to look at differences between the talk and the text. because obviously that could be also a source of contamination. And these differences are connected with the writing styles of the reports. And in my materials, there are 3 writing styles: the monologue style, the question answer style, and the you ask me style, which is a bit strange style, and the selection of relevant items. And in our survey among police officers, most of them said that they don't report the complete interrogation, but they only report the relevant items. And of course, what's relevant to them may not be relevant to others, but they show what is relevant for them in their police reports, and we can have a look at that. I shall give examples of these, each of these styles. This is an example of an interrogation with one police officer, and it's a monologue style. The policeman says, do you realize that it's forbidden in the Netherlands to have cocaine on you or to deal in it? Suspect nods. Police officer types for 24 seconds, which is quite long in a conversation. And he writes, I know that it is forbidden in the Netherlands to possess cocaine or to deal in it. And he asks, what did you get for that cocaine? For a balloon. A balloon is the packaging of cocaine. Suspect says 50. He types for 16 seconds. I received the amount of 50 euros a balloon. And then he continues to, what kind of people did you sell that cocaine? Do you know those people? Well, let's first look at the difference between the talk, between what the suspect said and what's written down. So the suspect nods and says 50, which results in 2 full-blown sentences. Well, this is obviously contamination. So a monologue style hides the actions of the interrogator. They disappear from the text. And the reported talk of the suspect is not recognizable as answers to questions. And it overestimates the cooperation and voluntariness of the suspect. You may have noticed that I said the policeman says and the suspect says, suspect not. Well, of course, I'm not, what I'm showing you is not the talk, but the my transcript, and also their translated fragments. So I first transcribed the text, the talk, and then I translated it. But it's very difficult to avoid saying this is what the policeman said. So I warn you that I'm going to continue to do that, but you must know that I shall refer to not to the original talk, but to translated transcriptions. And as we are talking about transcriptions, my own transcription also play a part in this whole world. Well, this is an example of a report of a question-answer report, and you can see it's an interrogation with 2 interrogators, and you can see that it's much more transparent than the monologue style reports. No, I shall first read it to you. Question, who else visit your uncle's house? Answer, my friends and my brother. Question, who are your friends then? Answer, right to silence. Question, how did you come by those fake drugs? Answer, I made it myself with wheat, flour and salt at home. With that, I mean in the kitchen of my uncle's house. Well, a comparison of this report with the talk shows that there were, in fact, 9 questions asked and only 3 reported. And one ironic comment was made after the suspect's answer, right to silence. The problem with the question-answer style is that it doesn't allow for a third position actions, that is like comments or evaluations. And this is what can be shown in the answer, right to silence, and then the question, how did you come by those fake drugs? He didn't report his ironic comment because that's not in the format of the question-answer reports. And also the fact that he didn't report his comments suggests that by the next question that he accepted the right to silence straight away. Well, in our institute, in the survey with police detectives, we asked, one of the questions was, how many of the questions do you report? And some of them said we report all the questions. Most of them said something like 75% of the questions. In my materials, only 20% of the questions were reported. And in another study in our institute with more serious crimes, about 60% of the questions were not written down. We also found that apart from the third position actions, repeat questions and follow-up questions were generally not reported. These questions may be asked when the suspect does not give an answer or doesn't give an adequate answer. And as these questions are often connected with antagonistic episodes, also in the question-answer reports, there is a tendency to report the conflicts and antagonism. The next question is a question, or the next fragment is from You Ask Me style. And in my transcript, in the left is the talk of the police and the suspect, and in the right is the corresponding report. So he says, is it right? Did Jairo address that boy? Yes, he addressed him. This is reported as, you ask me if it's right that Jairo addressed that boy. Yes, that is right. Well, this seems quite an adequate representation of the talk. You can see that this writing style requires more text and is more writer unfriendly than the monologue or the question-answer style. And this could explain the fact that only 16% of the interrogators' questions were asked in reports of this style. But I'm also not only interested in comparing the talk and the text, but also in the process of the typing. And in this transcript, I tried to combine or to show how the overlap between the typing and the talk, because this is two police officers did the interrogation, and P1 does the talk, and the second, the reporting officer, writes it down. So in the left-hand column is the talk, and in the same line is an approximation of what is written down at the same time. So he says, is it right, did Jair address that boy? Yes, he addressed him. Okay. And then he leaves a 4-second pause. And during that pause, or in that pause, the reporting officer starts writing. You ask me if it's right that Jair addressed that boy. And yes, that is right. And you see that while she's typing, after that 4-second pause, the interrogator continues the interrogation, and he asks 2 more questions. Did you close in on that boy with all of you or stood around him? Then this suspect said, we stood in front of the supermarket. In front of the supermarket. Did you have your hand in your coat, in his coat pocket? Well, you can see that the reporting officer is multitasking. She has to type, listen, remember what she heard, and select from what she heard the recordable items for her next entry in the report. So, and the conclusion of this fragment, which I won't show to you, but you can see that she is a bit in a muddle, and she eventually writes down, instead of we stood in front of the supermarket. Yes, that is right. So the summary from talk to text is the interaction is transformed in all writing styles, not only in the monologue style. And you can see a monologization of QA styles. That is, if only 20% of the questions are asked, you could say that 80% of the interrogation is monologue style. Well, there's a selective reporting of questions, which also is a result of the format of question-answer style reports. And there's an underreporting of antagonistic episodes. And this underreporting doesn't only depend on or isn't just a result of the incompatibility of talking and typing, or of the format of the question-answer style, but it may also result from the fact that police officers may not want to put their antagonistic actions on display. So now I'll go on from text to piece of evidence. I've already said that the suspect statement, or the report of the talk in the interrogation, is surrounded by other texts, which makes it into an official document. So there's in the police report first the identification of the date, the place, and the documents, introduction of participants and topic. So the reporting officer or the interrogators write down who they are, what their rank is, their number, and what they're going to talk about, what is the accusation against the suspect. And then there's a demonstration of correct procedures, because a lot of the things in the, some legal rules that you have to adhere to in the police report. And then there's a specification of participant roles. And I'll just focus on the last 2 items. Well, this is the caution. And after we informed the suspect that he was not obliged to answer questions and about what we wished to question him, he stated, and the question mark, the quotation mark, opens the report of the suspect's statement. That The caution in the Netherlands is much simpler than that in England or in Australia as well, I think. They just tell the suspects you don't have to answer questions. So that's quite simple, and no one has problems with that. So this is the substance of the suspect's statement. And then it ends, this report has been drawn up by us on oath of office and promise of office, respectively finalized and signed in Amsterdam on the 4th of March 2008. And then the reporting officers. I changed the names, by the way, of the reporting officers. You can see they call themselves reporting officers and not interrogators. So that is their communicative role in this document. There are two officers, and so it's not from the document. It's not clear. You cannot see which one was the officer who asked who did the talk and who did the writing. So, well, this, or the oath and the promise, this makes it into a valid document. The oath is an invocation of God, and the promise is, they say, I promise that this is an accurate description of what went on in this interrogation. Now we're going to zoom in on what the suspect said. And you see these quotation marks. So in between the quotation marks, it is what is supposed to be the suspect's talk. And the first sentence that the suspect is reported to have said is, I understand that you wish to question me and that I'm not obliged to answer questions. And the last thing he says, he is reported to have said, is, I have nothing further to state. Well, these two sentences are routine, and they do not correspond with anything that has been said in the police interrogation, but they do stress, or the introductory text, this shows the suspect's understanding and acceptance of the caution, and it stresses that he made this statement voluntarily. And the final sentence shows that his completeness of the statement. But I just said that he didn't. This did not happen in the interrogation, and suspects never take the initiative to end the interrogation. They are sometimes asked if they have anything else to say, but not in this interrogation. So this. And then the quotation marks close, and the police officers resume the floor. And this last sentence, after the suspect had read through his statement, he stood by and signed it. It underlines the statement, the suspect's agreement with the text, and identifies him once more as the author, in Goffman's sense, of the document, the author of his statement. And these surrounding texts implicitly instruct the readers on how to read this, the police report. So this is the textual environment of the police, the suspect's statement. And this is a conclusion from text to evidence. The police report is a demonstration of good work. So the policemen, they display that they are observing all the legal requirements. Police reports instruct readers on how to read it. Police report overstates suspects' acceptance and cooperation, and they emphasize the suspect's authorship. So I've first shown how contamination of the evidence can result from different writing styles or selective reporting. But here you see that the contamination is inserted by the police officers' routines of drawing up an official document. And then so a lot of what I've been saying thus far can be related to language ideologies, as described by Trinch and Eads. The ideology of narrator, authorship, I've adapted their description to cover my topics. So the idea that the suspect's story is his own production, and the ideology of decontextualized fragments, the idea that fragments from a suspect's story can be understood without their context. And this is that they can be related to language ideologies may explain the fact, or may explain the persistence and the fact that these practices are so widespread and difficult to change. Even in Dutch law, there are examples of these ideologies in the rules that are in the laws that are drawn up to protect the suspect from the power of the state. These laws are part of the laws that prohibit police pressure, that prohibit putting the suspect under pressure so that he will confess. And so, and the suspect is not obliged to answer, ignores the interactional context of question answers. I mean, it lacks an awareness of the interactional consequences of not answering a question. And that's also, you can see that in police reports when it's difficult for suspects to invoke this law, the right to silence without inviting comments from the police interrogators. Another thing is the statements of the suspects will be written down in the report of the interrogation as much as possible in his own words. Well, this ignores the interactional context and it stresses the authorship of the suspect. And this also lacks an awareness of the importance of the words of the police officer. Well, so far, this was contamination for you. We can ask now for how bad is it and what can we do about it? And maybe that's going to be part of the discussion or the questions, I don't know. But at least we can foster an awareness amongst legal practitioners that this is how it works, how the system works. So now I'm good, I'm right on time. So are there any questions?
Okay, thank you, Martha. Do you want to stop sharing your screen so we can see you more fully? And yes, indeed, there are many questions we have lined up for you here in the chat. So thank you everyone who's contributing. I've been trying to group the questions in my notes here, and there's a a sequence or a theme in the questions about monolingualism and translation and so on and so forth. So I'm just going to pick one of those at random. William Steele, could you unmute your microphone and maybe pose those sort of questions to Martha? And if you feel willing to, also your camera.
Well, look, I'll dispense with the camera.
Sure, no
I haven't got two heads, but
okay.
It is rather light in Australia.
Okay, no problem.
But the question, I was specifically wondering about Frisian suspects, because Frisian is, after all, a national language of the Netherlands. And I was wondering what happened specifically if a suspect chose to give evidence in Frisian, which I understand is their right in the Netherlands. And I believe other people have asked questions about other languages as well, non-monolingual interviews.
Well, thank you, William, for your question. I understand your question from being from Australia with minority languages and so on. And I must admit that I know nothing about Frisian suspects. I'm sorry, I will look it up, but I think that most of the trials in or the suspects in Friesland will, I think that it will be dealt with in Dutch mostly, but I don't know. I'm sorry.
Okay. Martha, sorry, William, I didn't mean to speak over you. Do you have a follow-up?
Oh, well, I was just going to say, look, that's sure. Yes, I would be interested if you are able to find out anything about this. I will be looking to see if there is any follow-up information. So thank you.
Okay. Yes. Well, give somebody your email address, and I'll look it up and I'll send it to you. Okay.
Thank you very much.
Thank you. So just to say also that we collect these questions and pass them on to the speakers and give them an opportunity to reply in our website presentation as well. A brief textual answer is also possible for the speakers. But Martha, there were a series of other questions about your data and whether in other ways, was it purely monolingual Dutch data, or were there other languages involved, or do you have experience of interpreted and translated interviews and their transcription?
Yeah, well, the first police interrogation that I recorded was an interrogation with, well, I don't know, Algerian or Moroccan man, and there was a French interpreter, and it was a very interesting interrogation, but it was so complex, and I still didn't, I felt I didn't know anything about police interrogations. So I told the police, if there are any more foreign suspects, don't call me, because it's over my head. I can't handle that. But this one interrogation I found very intriguing, and because I can understand the French, I could also understand what was happening in this, and I wrote an article about that, about understanding, about translating and understanding. Okay. But that was the only interrogation with a foreign suspect.
So we then have a group of questions about transcription, and sorry, I'm going to mangle people's names here. Sigurd Dont, would you like to ask your question? And then I've got some follow-up questions from others on this too. So if you'd like to unmute yourself, and again, if you're willing to, your camera as well. I think you're still muted.
Okay, thank you, Tim. And you pronounce my name quite well. I mean, it's,
Okay. Thank you.
hi, Marta. Thank you for your talk. Hi. I was interested in this notion of contamination. I mean, it's obvious that you know, when talking and thinking about transcript, there are the issue of quality. You know, there are quality issues. To what extent does a transcript transform what is being said, etc., etc. And your talk dealt with that in a very detailed and very lucid way. However, I'm wondering whether contamination is unavoidable. Is it would it be überhaupt possible to have an uncontaminated transcript, and what would such an uncontaminated transcript look like?
Well, thank you, Sigurd, for your question. No, it is, I think, impossible to have an uncontaminated, because it's impossible to transcribe everything. And so an uncontaminated transcript is a fiction. So, well, what you can ask then is, when is a transcription adequate? And it obviously depends on what uses the transcriptions are made for. No, I think there's a contamination always a contamination. Even with video recordings or audio recordings, you can't say that. I mean, it's always an imperfect representation of what actually happens, because it means video recordings are dependent on the camera standpoints or on the yes, well, so it's very difficult to completely reproduce the interaction.
Yeah, I'm even wondering whether it's überhaupt possible to think about quality in terms of contamination. I think discourse gets contaminated as soon as it enters the legal process, rather than being a quality issue per se. I mean, whenever you enter discourse in a legal trajectory, it will somehow be contaminated by the law, regardless the quality of its reproduction as such.
You mean regardless of the quality of the reports or the?
Yes, I'm sorry, I'm thinking out loud here. You know, so this is but
sorry.
Yes, I'm thinking out loud here. I mean, not really, but yes, I do think that even if it would be possible to have a perfect transcript, there still would be some contamination, some re-intextualization involved.
Yeah, that's correct. Yeah.
Okay.
But it's an interesting topic, and we may have an email conversation about that.
Okay, thank you.
Luna, Erica, you had a question that you wish to pose?
Yes, hi. Thank you. I'm just looking it up because I was so involved in the conversation. Oh yeah, I was wondering if there were any other, maybe less common transcription styles in the police reports that you didn't include in the study, or like, well, you included them, but you looked at, but then, you know, you didn't analyze them further.
Well, no, there are other styles, I think, but not in my materials. And my materials cover 3 police stations in Amsterdam, but I think it depends on the region or on the police station. And I know that for example, in The Hague or in Rotterdam, they also have a sort of form that they have to fill in with, they have to pick off things, but they aren't in my materials. So, but I analyzed all in my materials, there were those 3 styles, and I didn't say that, but they are not, most police reports are not purely those styles, because, well, as I already said, that in question answer reports there's a lot of monologue, but also in question-answer reports or in monologue reports, there is sometimes a question in the "you ask me" style. And that is, I think, when policemen want to add a comment or a question, that they can't report an answer of the suspect without the question, because it would be incomprehensible. So many of these reports are mixed style.
Yeah. Okay, thank you. Very interesting.
Thank you. Martha, there's a number of people have asked, is there a common practice of audio recording the interviews, whether for informal note-taking purposes or for formal legal purposes in the Netherlands, or is the only record of interview these transcripts?
No, there have been a number of miscarriages of justice in the Netherlands in the first decades of this century. And now there's a legal requirement for the more serious crimes to record the interrogations, and also for some of the interrogations, for example, with children, also to video record the interrogation.
Okay, thank you. And Deanne, I think you have a series of interesting questions, so you can pick and choose between them. Would you like to ask your questions?
Yeah, thank you, Tim.
You're very welcome.
Hello. Yeah, I just aware that I write multiple questions. Right, so my first question is, did your transcription show that the suspect provided a long response?
I don't know, I don't understand. If the suspect provides a long response, I transcribed the long response.
Yeah, and the follow-up question to that is, what the reporting officers did in this case, did they focus on reporting the talking to text, or on the evidence contained in the response?
Well, this is has something to do with the relevance of what they consider relevant. So if they consider that a certain answer of the suspect contains something that they can use for evidence, they would report it. And you can also see that in lots of police reports, there is some social talk. In the beginning, in most beginnings, there's social talk, and they report that, they call that the social interrogation. But sometimes at the end, there's also social talk. And that's, for example, many of the suspects, or some of the suspects were drug addicts, and they needed medical care. Or I have a suspect in my material who had just tried to commit suicide by slashing his wrists, and his arm was in bandages, but nothing of that is reported. So they do choose from what they think is relevant, and they also, you can see that they anticipate the future use of this of the police report, and they anticipate how prosecutors or judges will use the report for their business.
Okay, yeah, thank you.
Okay, I think we're nearly out of time, but I'll so rather than going to someone, I'll just pose the question. There's a couple of questions here about disputing the transcripts, and whether you ever have suspects who come back with, I didn't say that. And as we now know that some of these are recorded, which is the formal evidence, the recording or the transcript of the recording?
Oh, and is that a question, or
That's a question, yes, about the status of, sorry.
Yeah.
I maybe didn't state it much. I was trying to summarize 2 or 3 questions. So it's about the status of the transcript over the recording, where there is a recording,
Yes,
and whether the transcripts are of themselves disputed, as in I didn't say that or I didn't mean that, by some of the suspects. So you're aware of cases where that occurs in the Netherlands?
Well, first about the status. When an interrogation is recorded, there's always a police report, a written report. And it's the same kind of written report as the non-recorded. And when these recordings can be looked at by the defense lawyers and by everybody, but the practice is that nobody does it. It takes too much time, and they can do with the written report.
Mm-hmm.
And the other question was, are they disputed by the suspects? Well, at the end of every interrogation, the suspect, the report is printed, and the suspect reads it, or the interrogator reads it to the suspect. That's also reported on in the police report. I showed you after afterwards the suspect read his statement, and he persisted, or he stood by it and signed it. Mm-hmm. So they always ask, well, do you agree with this? And it's not disputed, but sometimes a suspect in my materials discovers a spelling mistake or something, or he says it was two girls and not three, things like that, more or less trivial things. They don't dispute the more serious discrepancies between what they say and what's written up. But that's but it also happens that the suspect refuses to sign it. Mm-hmm. I haven't come across any of those, but I know that from my research in the courtroom. And then the judge, even when a suspect refuses to sign it, it counts as a piece of evidence.
Okay. Thank you very much. So thank you, Martha, very much for your fascinating talk, which absolutely raises the issues that I think we're going to pursue throughout the day, or the morning for us. I'm going to move on now. So if I've not managed to capture some questions, we will send a transcript of all the questions to Martha, and she may choose to write sort of short textual answers, which we can reproduce on our web pages. If there's any questions I've missed, and so on. So thank you, Martha. And now we turn to the Aston Institute SILK team. SILK stands for Spoken Interaction in Legal Contexts. And I believe they're going to do a sort of block presentation with Kate, Felicity and Emma. So I will still be here to monitor and share the questions and answers, but I'll leave them to organise just how they're going to present within that. So over to you, Kate.
Yep, me first.
Yep, go for it.
Oh, is that showing okay?
Yes, that's showing great.
Lovely, thank you. You can never tell, can you? Okay, so yes, Tim's already said we are SILK, and this is about a project called For the Record, Applying Linguistics to Improve Evidential Consistency in English Police Interview Records. And what we're going to do with our 45 minutes is I'm going to give you a very quick overview of the whole project. And looking through the questions that have just been coming up, I hope I've answered some of those for our context, but there's going to be plenty more, so please do ask us afterwards. Felicity is then going to talk about one strand of what we're doing on some psycholinguistic experiments she's been running. Then Emma is going to talk about some of the factors about evidential consistency that she's been uncovering whilst we've been looking at this topic. So that's how we're going to divide this up. So I have 5 whole minutes to introduce our project here. So One of the central things about what we're looking at is the idea that interviews are evidence. So in this particular context, the England and Wales context, the interview itself is a piece of criminal evidence. So on the one hand, it's part of the actual investigative process, as you might imagine. It's there for the police to investigate an alleged offence, but crucially, it also becomes a kind of physical artifact, a piece of evidence presented as part of the prosecution case at trial. There are many more things I would say about that. We can talk about that later, but the basic point here is that because of this evidential use of the interview, and specifically the transcript or record of the interview, accuracy of that record is obviously crucial. However, what we see, and Martha's already been mentioning this and talking about this in her context, what we see is that the data go through lots of changes in formats. And so good, you're quite right, we can't avoid this, it has to happen. Things are going to change, but there are some quite substantial changes. So we have the original spoken interaction, which is of course immediately gone. We then have in the UK context, all police suspects interviews, which is our focus, they're all audio recorded, which of course has already lost a lot of contextual information. It's very one-dimensional. Then that audio recording is transcribed into an official police transcript. Now, generally, this is a ROTI, a record of taped interview. And then finally, we have a slightly bizarre thing here where the transcript is then read out loud in the courtroom. So every stage of this process is, of course, interesting to us as linguists. In terms of the integrity of the records and how they're used, all of these are seen as interchangeable. It's in case law and legislation here, that these are basically, they're interchangeable as copies. So many things we'd like to look at, but the thing that we are focusing on for this particular project is this stage here, this conversion from spoken to written. So we're running a project at the moment. It's a pilot project, and it's initially going to be with between 1 to 3 police forces by the time we've finished. And we're trying to analyse the whole process of this production of the ROTI from lots of different angles, lots of different methodological approaches. So we're interested in how they're produced, what feeds into that process, but crucially, what can linguists do to help enhance that process? And it's key to us that we're working with practitioners and taking into account actually what happens on the ground. And all police forces are different in the UK in this respect. So that's why we're working with individual forces. So we've got 3 strands to the project. Firstly, qualitative analysis of interview data, which Emma is leading on. Then the psycholinguistic experiments, which Felicity is about to tell you about, so I'll say no more. And then finally, my strand is making sure that we have the practitioner input in the form of focus groups and questionnaires and so on, just so we know that this will actually, anything that we come up with will work in practice, and we have their input throughout. What we're trying to do, what we're aiming towards, is producing transcription guidance, standardization and training, but we want to keep that flexible. We don't want to presuppose what is useful for practice. We want to find that out through the project. So that's all part of the plan. So this is what we're doing this year. We do want to expand it over subsequent years to, firstly, nationally. We also very much want to look into the courtroom presentation of that data, look at different jurisdictions and contexts. I think what you'll see today is it's different everywhere you go because of the different legal contexts. Interpreted and signed interviews. This has already been mentioned quite a lot in the chat. We really do want to look at this because, again, this is they're increasingly common, and increasingly it's important that they're captured properly. So if you're interested in all of that, please come and work with us. That was a very quick run through, but please ask more in the questions after. And now over to Felicity.
Hello, I will share my slides. Right, so as Kate just introduced, I hope you can all see that okay. I'm going to be going into a bit more detail about the experimental strand of our project. So we decided that it would be really beneficial to delve a little bit deeper into this transformation that police interview evidence undergoes within the criminal justice system, but within experimental conditions, under experimental conditions, so that we can control for various factors that might be having an impact on what's going on here. So the rationale behind taking this approach, and one strand of our project, is that we felt that it would be beneficial to build an evidence base to support this claim that aspects of the processing of police interview data can have a negative impact on the quality of the interview as evidence. And in order to do that, we feel we need to assess individual perceptions of different versions of the same interview data and discover which version is evidentially closest to the original, as that seems like that's the ultimate aim. And in order to do that, we need to manipulate different variables based on the standard processes which are applied to interview data within the police system. So, for example, we know that fundamental one, the conversion from spoken to written format. So the key research questions underpinning this strand is, firstly, are investigative interviews perceived or interpreted differently, depending on whether they are presented as spoken, audio, or in written formats? And secondly, which is a sort of later part of what we're going to do, does the choice of transcription conventions affect the perception or interpretation of an interview? So, for example, does more transcription details, such as intonation, pauses, volume, have an impact on interpretation? So it's this first question that I'm going to focus on today in this first experiment that we have already run and collected some data on. So the experimental design was we had 60 adult native speakers of English, and they were presented with the same police interview, which was just taken from publicly available footage on YouTube from a suspect interview in a murder inquiry. And we had participants asked a series of questions to determine their interpretation of that interview. So there were 30 of half the participants heard the original audio recording of the interview, which, well, a 3-minute subsection, I should say. And the other 30 saw a standard written transcript of that same 3-minute subsection of the interview. I'll go into a bit more detail about what I mean by a standard written transcript in a second. So the groups were matched for gender and age. There was a kind of approximate even spread of age between 18 and 71. The data were kept obviously as similar as possible across the two conditions, with just varying that mode of presentation. And immediately following having heard or seen the interview, participants were presented with a series of questions. I'm just going to play you a bit of the audio here now, so you can get an idea.
How do I know that you weren't involved?
Again, I shouldn't have any DNA reason to be involved, and again, especially with my past, to think that I could allow harm to come to somebody else like that is highly unlikely. And again, the fact that, as far as I knew, he was, changing, he wasn't as violent anymore, and he was going to sort the house out, and we were talking about, I'm carrying his children. I didn't. To think that I would know. Sorry.
No. Take a moment, that's right. Yeah.
Again, it's just more of, I couldn't even look at him to think that he'd be like that, even if he had those thoughts, let alone to actually carry them out, to know that at any moment I could have walked in and think.
Because I suppose the thing is, from someone outside looking in, is that what he's saying is he's gone to the address with his intent to kidnap her.
Okay.
And it's been quite convenient that you're at the garden having a cigarette and he's doing what he's doing.
Yes.
Do you see what I mean?
Yes.
And someone might say, well, hold on a minute, she'd have to know.
Yeah.
There's no way he could do that, or take those items, take some stuff with him, and the.
Okay, so I'm going to stop there just for the sake of time, as I'm a bit short of time this morning, but hopefully that gives you an idea of what the audio clip was like, what the interview was like. The transcript that we produced for the transcript condition, we produced it with two primary considerations. First being ensuring legibility for a lay audience, and secondly, ensuring that it included as much detail as possible given the above consideration of legibility. So that was the kind of balancing act that we had. And with these considerations in mind, we were able to include pauses, stress, overlapping speech, emotion. So this is the very top of the transcript that you can see there, just to give you a flavour for how it looked, and the key that we gave to people so that they understood the transcription conventions that we were using. So to the findings. I'm going to introduce the questions and the findings together to a bit of a time-saving exercise. So the first question being, on a scale of 1 to 5, please specify your level of agreement with the statement below. The statement being the interviewee is credible. So here they had to choose a sliding scale of 1 to 5, and we didn't actually get any significant differences there with respect to credibility. But there was interesting amounts of variation across both conditions. We also then had a follow-up text box. So what is it about the language used or how it is said that led you to the conclusion about how credible the interviewee is? And we had things here, you can see an example from the audio condition. She doesn't sound overly dramatic, by which I mean it doesn't strike me that she is deliberately exaggerating or crying, or her tone of voice, it doesn't sound like bad acting. And in the transcript condition, she interrupts often, highly unlikely, a strange choice of words. She makes vague statements, I don't know, I'm not sure, in contrast to her resolute response around not being concerned about leaving him with the victim. So these are the kinds of things we got in the text boxes. I'm not going to go into the text box data very much in this presentation, as we haven't done a full analysis of that yet, but we hope to do some interesting qualitative analysis of what we get in those text boxes to unpack a bit more about what it is about the language that's leading people to make the decisions they are in the quantitative data. So the third question, on a scale of 1 to 5, please indicate how plausible the interviewee's story is. And here again, we didn't get any significant differences, so there was a lot of variability, but it didn't pan out into significant differences between groups. Again, we've got the text box response here. Example, in the transcript condition, the comment around having those thoughts makes me think that she may know more than she's suggesting. However, does seem to show genuine upset for the fact that her partner has let her down. So for the sake of time, I won't go into all of these, but it just gives you an example of what kind of thing we were getting in the text boxes. So question 5, on a scale of 1 to 5, please indicate how sincere the interviewee is. Now here we get a trend towards significance. The transcript condition were more inclined to opt for less sincere, and the audio condition were more inclined to opt for an option of more sincere. So we had a sort of trend towards significance there, which was interesting. I'll skip the text box for speed. Question 7, on a scale of 1 to 5, please indicate to what degree the following words could be used to describe the interviewee's emotions at any point during the interview. So here they were just having to think about these descriptive terms, these adjectives, and think to what degree they would apply them to the individual, the suspect being interviewed at any point during the interview. And here we had some, I'll just go into the significant differences that we did have. So the transcript condition were significantly more likely to think that the interviewee was not relaxed than the audio condition, and they were more likely to attribute the term anxious to anxiety to the interviewee than the audio condition were. There was a trend towards significance with respect to fearful. So the transcript condition were more trending towards being more likely to attribute fearfulness to the interviewee. Question 8 was, on a scale of 1 to 5, please indicate to what degree the following words could be used to describe the interviewee's behaviour at any point during the interview. So again, we've got these adjectives that are picking out behaviour this time. So again, I'll just go into the significant differences. The transcript condition were more likely to think that the interviewee was agitated. They were less likely to think that they were calm. So they were trending toward, they were significantly more likely to think that the interviewee was not calm. There was a trend towards significance with respect to friendly, so but it wasn't really a significant difference with our sample set. So, but the audio condition were leaning towards being more likely to attribute friendliness to the interviewee. The audio condition were more likely to attribute cooperativeness to the interviewees. They were more likely to think that they were cooperative. The audio condition, that was, sorry. The transcript condition were significantly more likely to think that the interviewee was aggressive and defensive. And they were more likely to attribute nervousness to the interviewee. So sorry to be rattling through these, it's a lot to get through in this short time. So then question 9 was, in your opinion, is what the interviewee is saying true? So it's kind of bringing all that previous stuff together and seeing if we get a significant difference here, which we do. So the transcript condition were significantly more likely to think that the interviewee's story was not true. Not true. Again, for the sake of time, I'll just skip over the text boxes, which will be super interesting when we've had time to analyze them properly and do some proper qualitative analysis on that. We finished off with a question of guilt or lack thereof. And it was a kind of wild card because obviously a jury would never be expected to make a decision about whether a suspect was guilty or not guilty based on an interview alone. But we just wanted to put it in there as a way of saying, so in your opinion and based only on what you have heard in this interview, should the interviewee be found guilty or not guilty of being complicit in this murder? And interestingly, actually, anecdotally, a lot of people in the text boxes are just saying, I just don't have enough information to make that decision. And so they're being very good jurors. And so we didn't get any significant difference there. So to summarize the findings, participants who read the transcript of the interview were significantly more likely than those who had heard the original audio recording to perceive the interviewee as anxious and unrelaxed, to interpret the interview's behavior as being agitated, aggressive, defensive, and nervous, and to determine that the interviewee is uncalm and uncooperative, and ultimately to deem the interviewee's version of events to be untrue. So we want to do future experiments in which we compare different versions of the same data using different transcription practices, so including pauses or not, including intonation or not, and see if these that can make a difference to interpretation so that we can really feed into that future training in this area. The choice of variables for that second experiment will be informed by the wider research project, especially the focus groups from the Rotary clerks that Kate talked about, and the qualitative analysis from that first experiment I've just described. So just to kind of wrap up, it's perhaps intuitive that vitally important information is lost in the transformation of spoken interaction into written format, but it's potentially somewhat less intuitive that this lost information might have a negative impact on the evidential value of the spoken interaction when it's undergone this transformation. And this is basically an overarching aim of Silk, where we want to shed light on the nature of this impact and how it might be mitigated. And in this experimental branch, we want to move from the whether to the why. So if we know the mechanisms by which, the way in which evidential value is being negatively impacted, then we can take steps to mitigate that impact. So intuitively, we might think that in each condition, there's a different kind of input in the transcript versus the audio condition, which might lead to differences in the inferences and conclusions drawn due to their inherent differences in the two conditions. But the idea that I want to put forward in interpreting these findings is that the idea that there is this stable notion of input is in fact problematic, and the inputs themselves will be molded and shaped by our own prior experience, a sort of Bayesian approach to cognition. So neither the audio recording nor the transcript are stable inputs on which rational inferences operate. In fact, the top-down information, so our hypotheses, our prior experience, literally determine how we perceive the interview, and therefore will likely influence the conclusions that we draw about the person being interviewed. So you could view the transcript condition as a further distortion of the original interview than the audio recording, having removed the myriad low-level contextual information. So the reader will instinctively make sense of what they are presented with. They won't simply suspend their judgment on the information that is lacking. They'll fill it in. And I think we see this in our data. So this filling in based on prior experience will necessarily play a bigger role in the transcript condition than in the audio condition, as it's informationally impoverished. So we see that in the fact that we get this additional negativity attributed in the transcript condition than in the audio condition in lots of respects. So the transcript condition isn't just leaving information out, but it's encouraging a process of filling in. And these top-down filling in effects don't only impact rational judgment, they reach down into how the input is literally experienced at the most basic level. And this means that with all the goodwill in the world, a reader won't be able to avoid the effects of their priors when presented with a transcript. And the practical upshot of this is that the onus is on us to ensure that official police transcripts contain as much of the vitally important information contained in the original interview as possible. And that's where I'll wrap up now. Thank you.
Thanks, Felicity. So let me just move to sharing my screen. Okay, hopefully you can see that. Oh, sorry.
Oh, yeah.
I need to press share, that would be helpful, hey?
Now we can.
How's that?
Yes, that's good.
Great, okay. So, as I've been introduced, I'm Emma Richardson, and I'm going to present some of the factors that influence evidential consistency in police interview records. So just for a bit of background, I think this has been introduced partially by Martha, but across a range of institutional settings, we've got practitioners, or as we're going to refer to them in the paper, professional participants, eliciting and capturing spoken talk from various clients, or as we're going to refer to them as lay participants, and then creating records of that talk and later referring to those records in place of the original interaction. This process is textualization, and this textual trajectory often foregrounds the voice of the professional participants, marginalizes the voice of the lay participants, and this institutional power is worthy of exploration when that record is going to serve an evidential purpose as it does in legal settings. And, oh, excuse me. Basically, there's minimal recognition of the basic principle of non-equivalence of spoken and written text or that medium, and minimal scrutiny of the process of conversion from one to the other. So this presentation and what I'm going to talk about today draws on a review which began at the inception of the Silk project that Kate outlined. And the material that I've reviewed spans a number of contexts, but specifically I'm going to talk today about legal contexts and even more specifically England and Wales. So as Kate's pointed out and Felicity's presentation has shown, we're specifically interested in one particular part of this process, and that's the audio recorded suspect interview and the corresponding ROTI, that's record of taped interview. So what I'm going to do is present 5 potential influencing factors, and these are kind of put together in this diagram here. So we've got resource efficiency, ownership, agency, accuracy, and usability. And these are kind of, this presentation is a way to kind of present these to kick off some discussion. They're not sort of like finalised concepts. And the aim of the paper will be to bring sort of conceptual clarity to some of these concepts, which a lot of authors have spoken about. So just to give you sort of an overview of the situation in England and Wales, and this is very kind of simplified, we have spoken interaction evidence elicited, and that's at the interview stage, and then it's recorded. So you might get the witness statements, which are mediated through Q&A, but written as first person monologue and then signed, as Martha was talking about, or in specific cases where there might be a vulnerability as defined by Section 16 of the Youth Justice and Criminal Evidence Act, they might be video recorded. So that's for witnesses. For suspects, they're audio recorded, and then there's accompanying written records are made of those, such as the ROTI summaries. And then they're used. They're used in evidence collection and they're used in court. And this is a diagram that I've taken from some of Kate's previous work to kind of outline that process. So let's jump straight into these factors that I was talking about. And I guess on that diagram, you can kind of imagine these as being sort of like high and low, and we might want to toggle them to get like an ideal situation. So the first one is ownership. And what we're talking about here is the rights that lay participants have over their data. So at the inception of the interview, you know, they're informed that lay participants are informed that a recording is being made, and suspects are cautioned. But the extent to which they are aware or made aware of how that written or audio recording or subsequent recordings or records or transcripts will be recontextualized and repurposed is certainly questionable to their knowledge of that. Ownership over data is also temporal, so there's opportunity in the elicitation when officers summarise, talk back to them to kind of say, no, I didn't say that, or that's not how I meant it. But outside of that original spoken interaction, lay participants do not have the opportunity to input into any versions produced or reproduced. The other thing to say here is data is owned by the prosecution. So it's the prosecution that produce edited and summarised versions. It's the prosecution who present the interview records in court. And the defence can apply to challenge an interview record, or they can request that audio is played instead of the interview transcript, but it rarely happens. So the next factor is agency. Whose account are we hearing in interview records? And the first thing to say is all of the records are mediated through a professional participant's question and answer. And when a record is produced of that, there's certain features or even complete terms that are omitted from the record. And this impacts on agency because, for example, in the written witness statement, if the professional participant's terms are omitted and it's written as a record in first person, then obviously the agency is being played with there. And then features of the talk, such as if a suspect is showing resistance through silence or issuing like no comment statements, and they are, as we know from Kate's previous work, they can sometimes be transcribed in different ways or not at all. That kind of mitigates the agency that the lay participant has in the interview. And one way we can recognise that this is an issue and that lay participants might be striving for increased agency is that they can offer a pre-written statement that they will read out in the interview, and then that becomes the record. But this only happens when a lay participant has probably quite expensive private legal representation, which is not available to everybody. The next factor is accuracy. Sorry, I feel like I really am rattling through these ones, but accuracy to do with what was said and what was recorded. So this has been discussed by a range of authors. I'm just picking up on a couple here. So when we think, or when the assumption might be that the transcript is verbatim, it's not actually written down like word for word. So, you know, there's interpretive filtering going on there at that stage already. And then Eads did some work on what is lost and came out with 5 different kind of factors around what is lost. And I'm going to use some of Kate's previous work that informed this project again to kind of highlight what we mean by what is lost. So here's a transcript which does need a bit of explanation, but basically it's 3 different transcriptions of the same sort of aspect of the statement, and it's 3 different interpretations of what was said by Harold Shipman. So basically the issue here is whether or not Shipman said that there were drugs and actually drugs were found. So in Harworth's transcription here, we have Shipman saying, I don't keep any drugs, and that's from her professional hearing of the audio. The official police transcript said, "I've given your drugs," which is a bit of a strange phrasing, but at the trial it was transcribed as, "I have given you all the drugs." So if you want to go and see this in a bit more detail, I suggest going to Kate's chapter, which I've referenced at the end, Kate's 2020 chapter. But the importance is sort of cases are lost and won on these sort of details. And as you can see, accuracy is key in what was actually said and what's actually makes it into the transcript. Kind of a more fine-grained detail. These are some of the ways in which accuracy can impact on a transcription. So the first one we've got here is the official police transcription, just a couple of lines, looks fine, you know, looks verbatim. But when we look at Kate's transcription of this same piece of talk, you've got a couple of changes here. We've got gonna is transcribed as going to, so you've got that issue of standardization, cleaning up, and particularly cleaning up of police officers' talk. You've got some stress here and some different intonation, so it wasn't actually sweet or actually full intonation. We've got the exclamation mark to show there's something different about the way that that was delivered. You've also got the officer repeating that sod all, which is removed in the officer's talk. You've got pauses here, which again, I was talking about agency, removing those pauses removes the agency. 2.5 seconds is quite a significant delay. They're not in the official police transcript. So that's just some things to think about in terms of accuracy. The next one is usability. So I guess up until now, you might think of, you know, the audio and video recordings scoring higher than the associated transcripts or written records of that. However, usability of those audio and video recordings scores lower, if we're to think of it as sort of toggling on a scale or spectrum. So yeah, in the evidence process, gathering process, and in court, playing extracts of audio and video might be ideal, but it's less what we're calling portable and referenceable. And again, these are kind of terms we're just putting out there to generate discussion. They're not sort of like solid, we're not sort of copywriting them. So yeah, so the less portable, less referenceable, you know, not as easy to be shared with defence or in jury bundles, or you can't go straight to a page ref and get everyone to turn there really quickly. So if we're all to agree that written records are certainly necessary, the question is then how do we represent them? And this is a conversation that Gibbons was talking about in 2003 about readability. You know, we don't need to produce a full phonetic transcript of everything. We need to sort of strike a balance between what's usable and what's sort of necessary for that context. The final one, number 5, that I'm going to talk about is resource efficiency, a term that we've been playing around with again. So this is a trade-off between what is ideal, what's practical, and what's required for that particular context. So the main resource involved is in the production. So different forces have different amounts of roti clerks, different time available to spend on producing these, and actually they need to be turned around quite quickly in some cases. A full transcript might not be required in every context. So for example, where the case doesn't, you know, there's no facts in dispute, there's a minor offence, you know, you don't need to produce the whole full transcript, and maybe a summary will do. In court, you know, how much time does it take to present this evidence? Going back to what I was saying about usability, because you don't want to be wasting anyone's time in court. So I think the summary from this is that shorter and less detailed records are more resource efficient than full detailed transcripts, but at what cost for justice, and who is making those decisions and on what basis. And I guess that's where we want to maybe bring some more consistency into this process. Here I've put a actually quite small but potentially useful diagram to see how we might start mapping some of these different records onto the different factors that I've introduced. And it's a way in to kind of see, well, if you increase usability, what are the trade-offs? So I think I've got the roti on here in green. It's highly usable, but they're all scoring low on ownership, for example. But it's you know, it's sort of reasonable on resource efficiency. And I think one of the things we want to consider in the paper, and I don't have time to do here, is to talk about what happens when there's an imbalance. So accuracy and agency are two that are kind of quite paired, because once you start to reduce accuracy, or once you start to increase usability at the cost potentially of accuracy, then you're actually reducing agency. So it's starting to think about how can we toggle these specifically for the Silk project, and thinking about, you know, within the constraints of resource, what might be ideal and what might we be able to suggest. So some concluding remarks is that transcripts are definitely necessary, but they're always produced subjectively. They can never be exact, and they inevitably lose details. So I think someone was saying that previously in the questions. But detail should definitely be adequate and serve the intended purpose. And if we are to ask for increased consistency in the roti transcription, we need to be sort of mindful about making suggestions which are acceptable in terms of resource, what individual forces or whoever we're asking of those consistency or those changes to be made have the resource to do so. If this floats your boat, which I imagine it does for the particular audience, I just wanted to nod to the fact that we've got a Frontiers research topic open on this. It's called Capturing Talk, the Institutional Practices Surrounding the Transcription of Spoken Language. All of the speakers today are editors, along with Debbie Lukes, who's going to chair the panel later. So Felicity's going to talk more about it in the panel session, but just to say, if this is your thing, we have that there. And here are some very tiny references, but if you want to play back the presentation, you can pause that and check that out. Thanks.
Okay, are we over to questions now, I think? Yeah, okay. So I'm going to sort of go back. We had a few questions from Felicity's presentation. So Edith Tita, would you like, there were a couple of people who were asking about the selection of the categories that you were scoring. And so, and I think Edith had a question in that direction. So Edith, would you like to ask Felicity your question?
Yeah, sure. So I guess my first question was when the suspect is, when people are asked whether the suspect is credible versus sincere. So I'm wondering, my first question was about the distinction between these two, but actually what I'm really wondering is, how did you choose the various features on which they are rated? So and why, actually? Yeah,
no, it's a great question. And we probably could have done a whole 15-minute presentation on our process of coming up with these. So it was frustrating, so I had to kind of skim over it somewhat. But yes, absolutely. So we took a lot of time in coming up with them. And the aim was to get quite separately at features and dimensions of the interviewee herself, and also of her narrative, her story, her perspective. But you're right that sincerity and credibility are both getting at her as an individual. And the idea was that they come apart quite importantly insofar as, so I could be the most sincere person in the world telling you about microbiology, something to do with microbiology, but I just don't have the expertise to be able to say that. So that would make me non-credible, but very sincere. And so I suppose we felt that those were two important things that needed to come apart and be tackled separately. But more generally, we came up with, because I think there was another question to do with the terms, the emotional state terms and the behavior terms, which I think is a related question. So the emotional state terms were loosely, the basic 6 were taken from Ekman's 6 types of emotion, and then we kind of built on them with other ones that seemed appropriate for a forensic context, for this particular police interview context. And the separation between behavior and emotion came basically with respect to which emotions we're very much thinking along the lines of mental states, and with behaviors we're thinking of behavioral actions, behavioral features, dimensions that often, as I'm sure the question totally picks up on accurately, reflect the emotional state underneath. And of course that line becomes grey and blurred. So nervous was one in particular that we have under behavioral traits, but it's very intertwined and tangled with you could also refer to an emotional state by the term nervous. But ultimately that's where we're trying to tease those two things apart. That helps.
Thank you very much. I know we don't have a lot of time, but I was wondering if I could maybe contact you later. Just wondering about things like friendliness and nervousness and all of these things. Do we know that they affect the perception of suspects or witnesses or whatever? That's why I'm wondering why these particular characteristics were chosen to be rated.
Yeah, I mean, it would be fab to have a further conversation, and I think, you know, nothing like this, as far as we know, has been done. So we're kind of treading new ground, and we the terms on with respect, as well as I say, building on these six basic Ekman's 6 emotional states. We were picking them in terms of things that we perceived as a group to be actually influencing perceptions and interpretations, and that's, you know, after but it'd be fun. I'd love to talk further about it and have your feedback on that.
Okay, look, unfortunately, I don't know anything about any of this, but of course, it sounds like commonsensical things of what we think might influence the jury's decision and so on. And I'm sure there probably is literature on this. Anyway, thank you very much for everything, for their presentation. It's fascinating. I'll be keeping an eye on the results and everything. Okay, thank you.
Thank you.
Thank you, Edith. We are running up to time, but I'm just going to squeeze in one more question because there's a general question here that I think Alex Bowen, would you like to ask your question? There were other comments and questions on the methods and why you started with the very detailed transcript and so on, which I'm sure can be picked up in the chat. But Alex, your question, I think, had a more broad scope.
Okay, I think I'm quite dark, but I'm sure you can handle that. So my question is, I really like the 5-sided diagram comparing the different benefits of different forms of evidence, but just sticking with transcripts, how will we decide when it's good enough is basically my question. There's lots of problems with different kinds of transcripts, and sometimes we can see, well, this problem caused this legal outcome that was not a good outcome, but is there a framework for saying, well, you don't need to worry about this? And how will you convince the police in the end that it's worth putting X amount of resources into these transcripts to get it to a particular level? Just wondering if there's any thoughts about that.
Shall I answer that? Yeah, you're completely right. And that's exactly why we want to work really closely with practitioners on this. And also, just to mention, because I don't think we have, I mean, I used to be a barrister, so I was a CPS agent presenting this in court. And yeah, sometimes you don't need it. Sometimes a one-line thing saying everything was completely agreed is fine. There's no point in wasting everybody's time. And we're acutely aware of that. And it's also something that we hope will distinguish what we're trying to do and make practitioners be more willing to work with us. We're not going to go in and go, look, this is how to do the best transcript you've ever seen in your life, because nobody needs it. There are, you know, there's a practical user group at the end of this, and in court, time is money, right? There's no point if you don't need the full bells and whistles. And this is really where we're trying to go with Emma's stuff. So that's what we want to kind of be weighing up with those different factors that Emma's talking about. That practical reality is one of those factors that, okay, you've got to take all of these different factors into account. And what we want to try and work towards, and it is incredibly difficult, is a kind of model where it gives a means for weighing those things up. It's like, well, okay, how much of this do we actually need? In what manner will it actually make a difference? And particularly what we hope it will help with is there's very limited resource available here, and it will help target the resource to the right things. I think that's a really key part of what we want to do. So yeah, I mean, you're absolutely right though. We have to take the practical reality of this into account, and we hope we're doing that. But yeah, this is for that kind of model, the framework you mentioned, that's really what Emma's working on. And that's what we're hoping that will work towards. We like diagrams too.
Okay, excellent. I saw that comment in the chat. Thank you very much. Thank you to the Silk team for that great presentation on your project. It's really sparked a lot of discussion. And as before, with presentations like this, we hope that they are the beginnings of discussions, and the email the team at the Institute, and we will pass the questions on for answering more fully where that's possible. So it gives me great pleasure to move on to our next speaker, who we will give the full 45 minutes to that she's been allotted. We're only slightly late, so we're doing well. We're Professor Helen Fraser from the University of Melbourne. So Helen, if you'd like to queue up, I'll allow you to introduce yourself in your talk, because otherwise I'll spend more time. So over to you, Helen. We can see the slides well.
Thank you so much, Tim, and thank you so much to the previous speakers. I've had a fantastically interesting time listening to them all. I'm just trying to figure out my screen here. You can see it, you say, which is good, but it's on the wrong side of my screen somehow. There, that'll be much better. Okay, I'm going to charge in, and I need to start with a little audio test. So if we can just try this, I'm going to play a list of color words, and I just want you to make sure you can hear them, and if you can, make it to a comfortable volume. Hopefully that's all good. Nobody's complaining.
Helen, I couldn't hear them at all.
You couldn't hear them at all. Oh, I know what I've done.
Just me. I don't believe it was.
Sorry about that. That's me. I did the one thing I know not to do. Now, let's try again.
Red,
oops.
Red, blue, yellow, green, orange, purple.
Is that better?
Yes,
pink,
they're audible now.
Brown,
good.
Black.
Thank you very much. I'm glad I did that test, otherwise things would have gone horribly wrong. Okay, so quickly, the story so far, I think, can be summarized in a very brief manner, that transcription is really far more complex than a lot of people think it is. There is around in the world a sort of common knowledge attitude that transcription is just a sort of secretarial skill of writing down what's there to be heard, and the main thing you need to be is good at spelling. And another idea is that the transcript is in some sense a copy of the audio, just the same thing in a different medium. And I think the previous speakers have rather brilliantly debunked both of those myths. So I want to move on to something not completely different, but substantially different and perhaps even more complex. And this is a new use for transcription, forensic transcription, which is intended to assist the court in hearing the content of forensic audio. So what do I mean by forensic audio? Conversation recorded secretly. This can be done for a lot of investigative purposes, but we focus on the ones that are used as evidence in a criminal trial. And it's incredibly powerful evidence. If you record people having a conversation secretly about a crime of some sort, you can allow the court to hear those people making admissions that they would not be able or willing to make openly. The problem is that the secret nature of the recording means it's very difficult to control the quality, and they're often of very poor quality. So I have one example for you here. It's 14 seconds. Imagine listening to a 38-minute recording of similar quality. And if you feel inclined, you can jot down what you hear so that we can discuss more further later. Here it comes. So typically people jot down very few words when they listen to that. Nevertheless, this is crucial evidence of a serious crime. It's a conversation between a killer and his accomplice. The topic is a pact that has been made between the two of them. The killer has already been convicted and sentenced in a previous trial. And this trial is about the role of the accomplice. And this conversation is crucial evidence. The prosecution said that the pact was a pact to commit murder, which makes the accomplice guilty of murder. And the defense say it was a pact to conceal the murder, which is in fact admitted, and that makes him only an accessory after the fact, which is a much lesser crime. I can hear something, is that okay? Okay. So how are we going to let the court hear what is said here? And the answer to that is we're going to provide them with a transcript, and transcript is typically found quite valuable. So I'd like you to listen again now with the transcript. So most people find that quite helpful, and it was of great assistance in the trial. It helps the court reach a guilty verdict, and the speaker was sentenced to 30 years in prison. So in one sense, that's a great value of a transcript. There is just one problem. The transcript is incorrect. He did not say at the start, we made a pact. And it's quite easy to demonstrate that through acoustic analysis and also through asking people what they hear when they haven't got the transcript. Most of them hear nothing, as many of you probably didn't, but those few who do hear something, hear things that are completely different to at the start, we made a pact. So I think you would agree that this isn't really a fair trial, especially since, in fact, that audio was the only direct evidence that there was any pact at all. The trial was all about, well, what kind of pact was it to commit murder or conceal murder? But the only evidence, or the only direct evidence there was any pact at all, was this, this phrase or this sentence, which the speaker did not actually say at all. So how could this happen? Well, in Australian law, and it is similar in other jurisdictions, but many jurisdictions are quite different. However, we did have a really interesting presentation in a previous Aston series just a few weeks ago, talking about the use of this type of audio in Italy. And it's clear that there, at least, they have some similar problems. So I really commend that presentation to those of you interested in this topic. Now, it's, sorry, I was going to say Australian law and other jurisdictions allow transcripts to be produced by detectives from the case to assist the court. Now, it's important to point out, when people first hear that, they think that's crazy, we shouldn't allow that. But it's important to say, actually, the law isn't quite as crazy as that sounds. The police transcripts aren't just given straight to the jury. They're edited and negotiated between prosecution and defense so that there's an agreed version that goes to the jury. And if necessary, if it's not possible to reach agreement, the judge will review the transcripts and listen to the audio personally. And this has all been established by a case law in Australia since the 1980s. However, it's much more recent that it's come to the awareness of linguistic science. And we've been at pains to point out that even with those safeguards of, you know, having it agreed by the prosecution and the defense and the judge listening personally, there are still many problems with these procedures. They appear to work sometimes, that many errors in police transcripts are caught, but as is highlighted by that PACT case and other cases, they have got significant limitations. Now, I'm going to be skipping a lot of background here. I'm actually sick to death of giving presentations about all the cases. Somehow in the last couple of months, I've given an enormous series of presentations going through all the cases. So if you've come along hoping to hear that, I'm very sorry to disappoint you. You may be aware of this rather excellent new text handbook that's out. The Routledge Handbook of Forensic Linguistics has many excellent chapters by a lot of people here today. I recommend it to anybody. But I have a chapter in there that goes through a lot of the cases that have brought me to the topics that I'll be talking about today. And there's also a website that I'll give you at the end. And on there, I have several of those presentations that I've given recently, including one directed at linguistics generally, one more at phonetics, one more at translators, and so on. So I haven't got those all linked in detail, but please do feel free to contact me, and I'll give you the URLs for them. But I think from all those case studies and examples, I think it's very fair to conclude that using police transcripts for this purpose in this way is not good, even with the checking that goes on. And we certainly need a better way for providing assistance in hearing indistinct forensic audio. The question is, what should that way be? And we've recently established the Research Hub for Language in Forensic Evidence at the University of Melbourne, and my colleague Debbie Lokes is quite prominent in the discussion, in the chat, and also tweeting, and she'll be hosting the panel later on. And one thing I'd like to suggest that is, in order to answer that question of, okay, we need a better way, but what? It's easy to just leap to some ideas and start thinking, oh, that must be better, and maybe it would be better. But I think it's nice to have a broad understanding of the concept of transcript. What is a transcript? What can we do with transcripts? What should we never do with transcripts, and so on? And that's what I'd like to have a little bash at today, going through some of the factors that affect the reliability of transcripts. So this is work in progress. It's actually stuff that I've published on over the years intermittently. So what I'm going to present now is just my latest iteration. And the reason I chose to do this is precisely because we have a large audience of people interested in transcription from a wide range of backgrounds. So I'm very interested to hear people's perspectives on these things. So my current suggestion is that these 5 factors should be considered in thinking about transcripts. Maybe there are more, maybe there should be less, we can discuss. The important thing is that all the factors work together, but nevertheless, I think it is quite useful to separate them out so that they can be considered individually. So I'm going to have to charge through them, but hopefully we'll be able to come back and discuss in the panel later. So the first one is the medium in which the speech is heard. It's important to acknowledge, I will be talking about recordings, and I have sort of focused on recordings so far, but it's important to acknowledge that transcription is also done live. So we have professional verbatim transcriptions, and in that case, the medium is live speech, but it's kind of set up in a particular way to enable the professional transcribers, court reporters, parliamentary reporters to do their job. We also have live transcription in a more ad hoc sort of way. Of course, you can't really capture more than notes with that. You'd have to be able to write incredibly fast to be able to capture more than a few words. But nevertheless, this has been done a lot, and I'm sure it has been in other countries, but it has an interesting history in Australia through this concept of verbaling, which is taking notes, especially through police interviews, taking notes about what the suspect said, but putting words into their mouth that they may not have said and getting a false confession. This is an important part of forensic linguistics. And in fact, the origin of forensic linguistics arguably comes from noticing that kind of thing happening. Oops, sorry. However, most of the cases that I've been working on are recorded speech. And here we can distinguish between overt and covert, or open and secret recordings. We can also mention whether the recording is audio only, or maybe it might have video. Then importantly, we have to consider the recording quality. Now, of course, recording can be done to very high quality these days. We have fabulous equipment. We can mic people up with individual lapel mics and all sorts of things. It's important to recognize that with equipment like this, it's not just what you've got, it's how you use it. Now, you can have the best equipment in the world, but might not be used well. We also have the possibilities of doing various types of post-production, editing the audio after it's been recorded, or enhancing it to make it more aesthetically pleasing. And of course, this is done for soundtracks, advertisements, all sorts of things. This type of recording, as you can imagine, is vanishingly rare in forensic or even legal contexts. We usually have fair recordings, so the focus is on intelligibility, not aesthetic pleasantness. And it's useful to also mention that there's possibilities for having degraded audio. This could be audio that's, old tapes that have been left in a hot car or something like that. Or they could just be poor quality recordings done many decades ago. And then we have possibilities for restoring and remastering. What about poor quality audio of the sort that I've just played for you? This is often called indistinct, and for the casual listener, it has very low intelligibility, especially if there's low continuity. By that, I mean, you're just hearing bits and pieces of the speech. This can happen a lot in poor quality audio where there's a lot of noise breaking it up. You only hear a few words here and there and some hissing and noise. So indistinct audio of this type is usually discarded for most purposes, but sometimes we need to use it for the reasons that we've already discussed. And there is a lot of tendency here to focus on possibilities for enhancing this type of audio, making it sound clearer. And there's a lot of misinformation about this. I noticed the old movie from the 70s called The Conversation has started circulating again, and it shows quite unrealistic things. In fact, they openly acknowledge that it's been faked, what they do there. But it means that there's a lot of false beliefs about what's possible for enhancing. So in the packed audio was enhanced, but it really wasn't very clear. And I like to just point out the problem with enhancing. It's too difficult to do it with audio, but it's worthwhile to look at this visual example. So here's a very blurry number plate. And here's an enhanced version of that blurry number plate. And I think this is slightly clearer, perhaps gives a little bit more confidence that it might say something like DUN 150J or T50J. In this case, we happen to know the truth, of the ground truth, and access to the truth shows that that interpretation, even of the clearer one, is completely wrong. And importantly, you could never get from the clear one, from the enhanced one to what we know it really is, unless you knew what the clear one is. Of course, in forensics, we don't know what the truth is. And this brings up the key difficulty with enhancing forensic audio. It can serve to increase listeners' confidence in an inaccurate perception. So I'm going to have to really charge now the speech. This obviously, we have to consider what language and dialect is it in, whether it's formal, prepared, decontextualized speech, such as you might have in Parliament or even in court, whether it's conversational, colloquial, very context dependent, how many speakers, how much overlap is there? Maybe it's a monologue, some self-talk, somebody whispering to themselves. A very famous Australian case has that in it. Then we have to consider the listener. It's often overlooked or neglected that if you've got a transcript, you have actually got a listener as well. It's easy to overlook that when we're just assuming everybody hears more or less the same way, everybody's got the same language and literacy background. But I think it's important to really consider the listener and the perceiver. Of course, their knowledge of the language or dialect is crucial. Their knowledge and assumptions, expectations about the context are really crucial. And this is where I can introduce this concept of contextual priming. And I can go back a long way to bring this in to a famous experiment by David Bruce. He recorded a lot of sentences of the sort that you see there. I tell you that our team will win the cup next year. You said it would rain, but the sun has come out now. And he masked them with noise until they were 25% intelligible, and then played them to listeners under different conditions. And one of his main hypotheses was that if you give some context, it will make this audio more intelligible. And this was confirmed. So if you play sentence one with telling people you're going to hear a sentence about sport, they hear better. And the same for the second one. If you tell them it's about weather, they hear better. And that's what we call priming. It's now very well known that knowing the context, having some contextual expectations primes your perception like a pump, gets you ready to hear the words that are just going to come. However, in among that, David Bruce made a very surprising discovery. His second hypothesis was that the wrong keyword would make the audio less intelligible. In fact, he was so sure that that would be true, he nearly didn't bother to test it. But luckily he did go and test it because this was disconfirmed. The wrong keyword does not make the audio less intelligible. It assists just as much as the right one, but it helps people to hear something other than what was spoken. So whereas sport helps you to hear that sentence, I tell you that our team will win the cup next year. If you preface that with food or travel, obviously they don't magically hear that particular sentence that I've written there, but those are examples of the kinds of things that people might hear. And most importantly, it's with very little diminution of confidence. People are just as confident in that hearing as they are in the correctly primed hearing. So we can say then that context is a double-edged sword. It's very helpful if it's reliable. It's very misleading if it's unreliable. And listener knowledge is really crucial to understanding. Most importantly, listeners' confidence is a poor indicator. So now let's race on to the transcriber, excuse me. The first thing we have to consider with the transcriber is their skill. Do they have appropriate literacy skills just to write down what they hear in that language? Perhaps they might be an accredited transcriber. Perhaps they might have some technical understanding of linguistics. All of these things are very important. Another really important thing, and one that I hope comes up in the panel discussion, because I think it develops very nicely from the sorts of things we were talking about before with the previous presentations and what I'm trying to say now in a very rushed way. The next most important thing is the transcriber's understanding of the purpose of and end user of the transcript. So if the person's writing a transcript as a personal record, as a so-called aide-memoire, an assistance to their own personal memory, that's one thing. If they're making an official record as a verbatim transcript, now we know in linguistics we can say, well, they're not really verbatim, they leave out some words, but there's an important category of official records that is considered to be a verbatim transcript. And then, of course, the purpose might be linguistics research, theory development, language documentation, all sorts of things. Next, most importantly, we have to consider the independence of the transcriber. Is the transcriber involved in the project in some way? And I'd like to reference this work by Benji Valde. It's quite old, but it's still very, very important. It's a cautionary tale for linguists that think, oh, I'm a linguist, I can do transcription very objectively. I haven't got time to go into detail, but he showed very clearly that transcripts done by linguists who had a particular relationship with the material were greatly affected by their expectations. And there's also this great novel I read recently. It's very short. I recommend it to anyone who's interested in transcription. It's called The Godmother. Again, I don't have time to go into it, but I'm sure you'll be most interested in the story that's there. It's all about a forensic transcriber who is far from independent of the material. Finally, and perhaps most importantly, the role of the evaluator, who is going to check the transcript and make sure that it's correct. As anyone who has done a transcript will know, you don't just write down the transcript and stop. You have to check again and again. This is often done by the transcriber themselves. It might be done by the speakers. So I've transcribed a whole lot of your speech. Now I might give it to you to see if you agree with it or not. Or it might be done by a third party. So there's a lot of variability there. Again, we have to consider the independence of the evaluator and especially their access to any contextual knowledge. We saw how important contextual priming is. What knowledge do they have? How independent are they? Are they just remembering through having been in the context themselves? Are they getting information from a third party? All of these things are really important. And what method are they using for evaluating? For many purposes, it's quite okay to read the transcript and follow the audio. For many others, it is dangerous. And this is where we have what we call textual priming. Contextual priming we've spoken of. Textual priming is the phenomenon whereby if you're following especially indistinct audio while looking at a transcript, that transcript affects your hearing, your ears follow it like subtitles. And we saw that with the packed example that you heard right at the beginning. Unfortunately, our ears tend to follow the transcript like subtitles, even if the transcript is wrong and actually implausible as it is in that particular case. So there's a very quick framework. How will we use a framework like that? If indeed we choose that framework, it might adapt it, but what's the value of having a framework like this? Well, let's start first by thinking about court transcripts. By court transcripts, I mean transcripts of the proceedings of the court. What's the judge saying? What are the witnesses saying? What are the barristers saying? This is always documented to have an official record. Very often these days that's done via a recording, and the recording is a fair quality overt recording. The speech is formal, monitored speech, and the judge is responsible for making sure that people speak one at a time and making it relatively easy for the transcribers. The listener, the transcribing listener, I mean, is primed with reliable information. And this is quite interesting. I'll take a second to just say what I mean there. Until quite recently, and even still in some courts, the transcribers are present, so they'll be tapping out the transcript on a transcription machine and then writing it up into orthography later on. But very, very often the material is transcribed from audio. And it's often assumed, of course, it'd be much better if the transcribers had the audio than just rushing along. Funnily enough, that's often not the case. And the reason is that on the understanding that they have the audio and they can replay it, they give people less time, they farm it out to different people, they have less reliable contextual knowledge. So quite often the quality is lower when the audio is available than when it's done by somebody there in the court. A court transcription is almost always done by skilled transcribers. It is somewhat variable, but they have some level of accreditation. It's evaluated by the listeners present, typically by the judge and the lawyers. And the cost of any error is medium. Of course, we don't want incorrect things on the public record, but it's not life or death if you get a few words wrong. Now compare that to forensic transcripts. That's transcription of forensic audio, like the packed audio that I've played you earlier on. These are typically poor to very poor. The ones that are fair, sometimes they are fair, but there's no issue about the transcript there typically. They're covert. That means the context and the content are both contested. We do not know the truth of what was happening at the time, and we don't know the truth of what was said at the time. Very importantly, the purpose of the transcript is not to create an official record, but it's to assist listeners to hear what is said. And also very importantly, and this is a big difference from the approach that's taken by the Silk people, when we have forensic transcription, and perhaps this is also true for interviews, I'm not sure, the courts consider it very important to leave the interpretation of the meaning and significance to the jury. The transcript is intended to help them understand the words that are spoken, but still leave open to them. Were they sarcastic? Were they sad? Were they truthful? We don't want the transcriber imparting their knowledge or assumptions about those things. So this is a quite specialized purpose for a transcript and very unusual in linguistics as well. So I hope we'll have some time to discuss that later in the panel. The transcriber, if it's a police officer, they have zero expertise or training of any kind in doing transcription. And of course, they're highly involved. They're certainly not independent. And interestingly, the evaluator, as I've tried to show earlier, the safeguards that are built into the legal process involve the lawyers and occasionally the judge evaluating the police transcript. And unfortunately, the procedures that are used for doing that really treat the forensic transcript as if it was very much like a court transcript. And presumably that's because they have experience and very familiar with the concept and use of court transcripts. Even the concept that in Australia, at any rate, I don't know so much about other countries, the transcript of a forensic audio recording is called an aide memoire. In other words, an aid to memory. If you press barristers or judges about that, they'll say, oh, well, we say that, but it's really an aid to perception. Well, to me, an aid to perception and an aid to memory are massively different things. And there's an interesting history about how that term came up. I'm happy to discuss that later on if you want, or it's written in the references that I gave earlier. So here we have an amazingly paradoxical situation where the audio that is the worst quality of any that ever appears in any kind of legal context, and it has the highest stakes. This is crucial evidence. It's not just the evidence that they get from it, because the jury feels they're hearing it with their own ears, it affects their interpretation of other evidence as well. So it's very bad quality. It's very, very important. It's transcribed and evaluated by people who are less skilled in those fields than even the bad police transcripts that the Silk people were talking about. Those transcribers and evaluators have more skill than police and lawyers. My apologies to any lawyers or police who are here. I don't mean to be bagging you out, but let's face it, that is the truth. So this is a very bad situation. The question is, what should we do? Now, a very common suggestion, especially from linguists, and I want to emphasize that this includes my former self. If you read some of my early publications in this area, I was saying we need to use experts to do this type of material. So some people say we need experts in linguistics, sometimes experts in phonetics, or sometimes experts in field like conversation analysis, where you can do the very detailed transcripts. There's some variation as to whether they should be checking the police transcripts or preparing independent transcripts. Both of those have major downsides. Checking police transcripts, there's a very high risk that the expert might be primed or influenced through textual priming from the police transcript. Remember that in all the experiments that we've done, listeners are influenced by a transcript, even if they reject it, and demonstrably influenced in important ways. And another thing is, and this goes back to some of the things that were being said earlier by Kate and others, the importance of keeping this practical. The aim here isn't for the linguists to get a good idea of what's said in the audio. The aim is for the jury. We have a jury system in Australia, obviously, so the court, I should say. The aim is for the court or the jury to get a reliable impression. So that means we have to take into account how is that transcript going to be used with that audio after they leave our hands. And it's certainly in Australia, and I suspect in other cases, the lawyers and the judge consider the expert opinion just an alternative opinion for the jury to consider. They typically provide the police transcript and the expert transcript and then say it's up to you. I think personally that there's some problems with doing that. So yes, we want to have linguists involved, but do we want linguists to be doing the kinds of transcripts that we normally do if we're doing phonetics, fieldwork, conversation analysis, and that kind of thing? And I'd like to suggest that we might want to modify that a bit. And some of the reasons have come up earlier, but I think in some cases I'd like to even press those reasons a little further than has already been said. So let's go back to those factors very quickly and consider some typical linguistics transcripts. Linguists are very, very unlikely to have experience in recording material, in transcribing material of such extremely poor quality. The speech that linguists typically transcribe, yes, sometimes it is conversation, informal or colloquial conversation. But then we typically have a much higher recording quality. So if you're doing conversation analysis, you'll have high quality recording with mics on individual speakers, at least as much as possible. Here's a very important difference. In linguistics, even when the audio might be somewhat indistinct, the listener almost always knows what is said. Sometimes they might have designed the material, written it out so they know what it would be. Sometimes they were there present during the conversation. It's a rare thing that we are listening to material which is so indistinct that we can't hear it and we don't know what it is. Another thing is the purpose of linguistics transcripts is usually some form of explanation, some form of theory development. And I won't have time. I do have another demo and there is one in other presentations that I've done, but I know I won't have time for it now, but I could do it later on if there's interest. And this is where I like to distinguish between what I call evidence 1 and evidence 2. Where one form of evidence is backing up. So you've got an opinion or a theory, if you like, and you want to give evidence to support that theory. The other form of evidence is the evidence that you used in order to form your opinion about what was said. And they're quite different things. And then we've got this whole thing about whether the transcript is complete or uncontaminated. I hope we'll be having some time to discuss that in the panel. So I know I'm extremely close to being finished. The research hub, we have 2 strands of research going together. The first one aims to create a better system. And here I think this term reliable is quite useful. We don't want something that is fully accurate or fully detailed, but we want something that is helpful and not misleading. We want to have an evidence-based process that is carried out by accredited practitioners. So the experts are designing the process and accrediting the practitioners. And this is similar to DNA and other responsible forensic sciences, where you don't get Professor so-and-so going into the court to discuss the particular DNA analysis. They're the ones that design the process, and the accredited practitioners create the report that goes to court. The second strand is to work with judges, hopefully to change some of those procedures so that we can still keep the factors that are really important in the law, but hopefully move them a little bit away from the confident false beliefs of educated common knowledge. And I've got a few of those there, but I won't take time to go through those right now. A parting thought: it's not what you don't know that gets you into trouble, it's what you know for sure that's just not so. There's the websites. The top one is the research hub, and the bottom one is the one that has a lot of materials, and it's the easiest one you can contact me through either of those. You can also contact Debbie through the top one. So I'm sorry to be so rushed, and I'm sure I'm not quite over time, but nearly.
Thank you, Helen. I think we will develop discussion in the panel discussion, but there were just a couple of questions which, to save a bit of time, I'll summarize here, which was about, so we had Edith and then William asking questions about admissibility of covert recordings and whether at some point on a sort of a quality curve, they should simply be inadmissible, and whether your framework can help determine that, I guess, is a background question to that.
Yes, that's a very good question. I think if we have independent agencies doing transcription, a lot less material will get a transcript and will not be put forward. At the moment, if there's you have to argue case by case. It's very difficult to have a blanket rule. If this and this and this, it's untranscribable. I think the important thing is to have a system which has a quick weeding out process, but I think it's important to look at each piece of audio first.
Okay, so thank you very much. There's no immediate questions other than that one which was raised, and I guess around the ethics of covert recording, which blends into all these questions. So what we're going to do now, we are going to take a 5-minute break because we've had a pretty intense morning and concentration is required. So we're going to have a 5-minute break, and we will be back at 20 past the hour, I try and say in a time neutral way. Currently in the UK, it's about 11:15 in the morning, so we'll come back at 20 past the hour, and when we're going to have the panel discussion, which is going to be led by Debbie Lokes. So if you are hanging around your computer and you've thought of more questions for Helen or more general questions for the panel bringing together the themes of what we've heard, please do continue to put those questions into the chat box. And we'll pick them up after the break. But yeah, so it's probably easiest if you stay logged on and just simply close down your cameras and microphones, which most of you have anyway. But we'll come back to the room in about 5 minutes. So thank you very much all. Okay, welcome back, everyone. I have my coffee, only the third cup of the morning, so I'm doing well. Right, so can I ask all the speakers and Debbie to allow themselves to be seen? I'm sorry, because of the gallery view, I'm not sure if some people are hiding. I can see Helen and Martha and Kate and Felicity and Debbie. I can't see Emma. There she is.
Hi.
Okay. Hi, Emma. Sorry. All present and correct. So I'm simply going to pass over to Debbie, who's going to be chairing the session for us. As Helen, I think, mentioned, Debbie is working in their hub. But I'll allow you, Debbie, to introduce yourself and then to start the questions. There are a couple of questions in the chat. Keep them coming, but I'm sure we can very easily have a 40 minutes discussion from just simply between the speakers. So we'll be prompted by your questions, but we'll see where the panel leads. Debbie, over to you.
Hi everybody, my name's Debbie Lokes. I'm actually working with Helen Fraser in the Research Hub for Language and Forensic Evidence at the University of Melbourne. And welcome to the panel session, I should say, as well, for the perspectives on transcription in criminal justice. I heard Tim talking about his coffee. I think it's time for a wine in Australia, or maybe a herbal tea, but anyway, keep it professional. So I think the really great thing about a panel session is that we can bring together themes that have been running through all of the talks, which is really fantastic. And there's been a lot of those that I'd like to link to. But we haven't had time for questions for Helen. So I've just direct messaged a couple of people that I was hoping would be able to start off some questions for Helen. So I think the first person I wanted to call on was Erica Luca, if she can ask her question to Helen directly. Sorry, Luna Erica. Sorry,
yeah, it's
Luna.
okay. No, it's like, you know, two first names basically. I was just wondering about, you know, covert recordings, if there's any ethical restrictions on them. So if you can use them in any setting, or, you know, because it's kind of strange, or for some reason it feels strange to just record somebody and then use it in a public setting without their knowledge. So I was just wondering if there was anything about that you knew, Helen.
Well, I'm sure Kate could give a better answer than I can, but I think it's pretty simple, really. Yes, you certainly can't just go around recording anybody and using it in court. I should have made clear that these covert recordings are obtained on behalf of police with a warrant, so it's very strictly controlled what you can do. So that's a good question. Yeah, it was my oversight to not mention that.
Explains a lot.
Thank you, Luna. So Mihaela, I don't know if I'm pronouncing her name right, but I think Mihaela had a good question for Helen as well.
Hi, everyone. Thank you, firstly, for all the presentations. I thought they were all fascinating and I've learned a lot. So I'm a first-year PhD student and I'm studying the language of police interviews. And in order to do this, I have to transcribe these interviews. But I also have access to the official transcriptions that were put together by the police themselves, by the official transcribers. So when I'm transcribing myself, I'm foreseeing that possibly there might be words or utterances that I don't understand, that are unclear to me. And so I was planning on going back to the official transcripts to check to see what they've put. But based on what you've said today, Helen, I'm now thinking that I perhaps shouldn't do that. I was thinking that maybe some of the words that I don't understand could be police speak that I'm not familiar with, but that the official transcriber is familiar with. So I thought that might be helpful, but yeah, now I'm not so sure. And I was wondering what you recommend.
Again, I think this is probably one more for the Aston people, but just to, since I've given you that framework, just to bring in some of the things from there. A police interview is an overt recording, so usually there's more than one person there. So there are much greater possibilities for checking reliability that way. However, as we've heard earlier, there are often errors in police interviews. So I would strongly recommend that you should first do a transcript without looking at the official record, and then check against that, but don't be too inclined to think, oh, I must be wrong if it's different from the police record. How does that sound to you, Kate?
Yeah, I mean, hi, Mihaela, nice to have you here. Yeah, I mean, I have similar things myself with my police data that what I've actually found quite interesting is even listening back to some of the stuff that I've used in the past now, I hear it differently because I've got better kit these days than I had 10 years ago. And I think one of the things that's really important to recognize that I think we're all saying is it can never be perfect. I think Helen's advice is really good, that you do your own without reading the transcript, because of the priming effect that Helen's written about, you know, many times over the years, which I think is really important. I mean, it depends. I mean, yeah, I mean, this is a rabbit hole that you can lose yourself down, which I'm happy to be in right now. But I think, you know, when it's your first year of your PhD, we don't want to scare you off too badly, you know. And it's the question of your transcripts being good enough. It depends on your purposes. I think one of the things that I think is generally most absent is a recognition that you can't hear something properly. There's always the tendency to want to fill it in, like you know, Felicity talked about this filling in effect. You kind of want to, you know, put something there, and it's really hard, particularly when you're analyzing it. You kind of, it's really frustrating when there's a gap, but I think recognizing those gaps is important. And certainly from my experience of doing my PhD, looking back now, I wish I'd done that a little bit more. There was I think one in particular, there were some technical medical terms that I guessed at, or I looked them up. You know, Dr. Google was helping me. So, you know, this is a bad idea, and I'd do it differently now. But I think the Mary Buchholz has written some excellent stuff on this. So I think, you know, that was where I point you to. She wrote something brilliant, looking at her own transcripts and the inadequacies of her own transcripts. So yeah, read Mary's work, and good luck with it. I really want to hear about your project.
Okay, thank you so much, Helen and Kate. That's really helpful, actually, because it is something that I've been thinking about over the past few weeks. So I'm so glad I've had this opportunity to actually ask the question. Thank you.
Just pop back in if I can, with just to follow up on what Kate said. First of all, I do want to really emphasize, please don't, not just you, anybody, think that everything I said about indistinct covert recordings must apply to all transcripts. It's the horses for courses is really an important thing. But the other thing is, that, also following on from what Kate said, the mark of an expert isn't to always have an answer. The mark of an expert is to know when you don't know the answer and nobody else knows the answer either. There are some things where we just don't know with sufficient certainty for the purpose. And that's where with the framework, it's really useful to just come back to that and think, well, what is the purpose here? Is what I'm doing useful, helpful in that purpose, or is there a potential for misleading?
Thank you, everybody. So we might start now broadening out the panel discussion. And again, I just wanted to thank all of the speakers. We've heard some really interesting talks today and heard a lot of insights that have come from knowing about practical use or knowing how people will respond to real forensic audio. So we've heard some really fantastic things. All of the speakers talked about what to do. So I think that came from every person that spoke today. So we know what the problems are, what are we going to do about it? And some solutions or suggestions have been offered. And I thought maybe we can ask for people's personal opinions on what has worked when you've tried a solution. Has it worked? Would you change it? Maybe some more personal insights would be really interesting from the teams that spoke. And maybe Kate could start that, because Kate, you were talking about your experience as a barrister as well. So some of the things
so
that
I'm not quite sure exactly which bit you want me to address that, because I mean, I haven't fixed this yet. I've got lots of ideas about how this should be fixed, but
you haven't managed to actually practically apply anything yet.
Well, I mean, in terms of producing transcripts, no, I guess not is the honest answer. This is what we're in the process of doing, but mainly because, I mean, really this came about, it was, if I can digress a little, this came about from being in practice. This came about from the fact that I did a classics degree. I didn't study linguistics, but I had one lecturer who quite liked linguistics. And so I learned a little bit about it and then became a barrister and was then in court reading out the transcripts. And just that tiny bit of knowledge was enough for me to go, this isn't right. This is just not right. I'm standing here reading this stuff out and I'm injecting things like intonation and pauses and emphasis and simple things like making eye contact with the magistrates for the bits that were really, really bad for the defendant as I was prosecuting. And I knew this wasn't a good idea. So it comes from that very practical application of wanting to fix that. Then I came to do a PhD, I had the opportunity. And the thing is, linguistically, that's not interesting. Everybody in linguistics knows this stuff, right? You say that spoken language and written language are different. Everyone goes, yeah. And so it ended up being quite a small part of my PhD. And I did it on, lots of other interesting stuff, of course, but it wasn't the central idea. And it's really just, it's then realizing that this issue still hasn't been resolved. We're 10 years on from when I started that. And it's still something that you think is so obvious, but isn't. It's still happening. And I think this is one of the things that, this is why I like being at Aston, and something that Aston is very keen on. It's like, yes, but what do we do about that? We don't just want to do linguistics into a void. The linguistic basis for this stuff goes back to the 70s. It's not new in that sense, but the practical application is incredibly difficult. I think someone in the chat earlier was talking about, well, you need to get to legal professionals about this. They're the ones who need to be the audience. Yeah, but who is that? Yeah, there isn't, it just simply isn't that easy to go in and find the right audience. So what seemed to me like something that I could just have a minor diversion from my legal career for a year or two, do a bit of research and then fix, has turned into 10, 15 years of my life, because it's just not that simple. A lot of that is to do with the legal process itself. It's not that easy to make a change. But who is it you're trying to get to change? It's every aspect of the process. We've all been talking about various different aspects. You've got the police, you've got absolutely central to this are people who are accused of crimes. Now that isn't a reachable user group. Those are the people we really want to get to. So the actual practical application of this is really fiendishly complicated. So this is where I've ended up working with the police, because they are a nice, convenient user group who listen to research, particularly in the UK, which is brilliant. And so I have lots of people within the police who completely agree and think this is absolutely right and want to work with us. But whether that changes anything or not is still a different matter, because then who do you need to get that change to? And that's why we focus the SILT project on, well, how can we help you do transcripts better? That's where this has come from. It's like, this is to us the best way to target this, because there are practical things that we can do there to help transcribers, because no transcribers do an incredibly difficult job. Peter, hello. How many judges does it take to change a light bulb? It depends if it's you or not, Peter. I'm sure you're very good at changing light bulbs, but yeah, judges. Let's get on to judges. Yeah, you see, Peter. Yes. I mean, you need to ask Peter about what it's like to try and get the judiciary and the legal system to change, really. If you find the right people, that's great, but it's individual. And trying to find that kind of broader, large scale change is incredibly difficult. Peter, do you want to share your thoughts on that? Sorry, I'm taking Debbie's role here, but it's just nice to see you here.
Oh, it's nice to be here, Kate. Nice to see you too. It really is very difficult to budge the legal system in any direction at all. Very, very difficult. Lawyers are great at making, even when change is forced upon them, at making it look like what used to be. Because we're always looking backwards, we're always relying on precedent, we always know what's worked in the past, so it should work now. So it is extraordinarily difficult to move things.
Mm-hmm. But
yes,
your courts were never like that, right?
My courts were like that, and I was getting offside with a lot of my colleagues about a lot of issues.
So do you want to tell us your thoughts from the bench on this?
Oh, look, this is, it's just, I can see the difficulties of trying to get change. And I think, if I may say so, that we've done the right thing. Helen's done the right thing in getting police and prosecutors as the ones involved, because we're more likely to get change with them than we are with judges generally, I think. Everybody says, oh no, but it's always worked this way with everything. And the High Court says it in Butera, so we've got to follow that. And the High Court actually doesn't say that every police officer is an ad hoc expert through listening many times to the recording. It says it is possible for a police officer to become an ad hoc expert by listening many times to the recording, but that's kind of become elevated into the principle that every police officer who listens to the transcript an unspecified number of times becomes an ad hoc expert in what was said. And, you know, as Helen shows, it's nonsense, but to get it changed is proving very difficult.
And I've just had a nice message saying, oh, well, I should introduce who Peter is. So Peter is, and do you still identify as a judge, Peter?
No, I'm a retired judge. Yeah.
He's a retired judge, and he's a linguist. So we're lucky to have him in Victoria.
I was a judge for 29 years on the Federal Court of Australia, the longest serving judge in the history of that court.
And I noticed Helen nodding vehemently, so I thought you might want to say something there, Helen.
One of our biggest champions in helping to get our linguistics call to action heard in Australia. So, and he has a lovely dog as well.
I have a noisy dog, my security officer.
Well, I thought we might also just follow on from another theme that came up that might be a bit controversial. Helen was talking about the fact that maybe there's a different point of view between Silk and some of the things that she was saying. I'm not sure, maybe it's a little more nuanced, but the idea of putting in interpretations and meanings and context into the transcript. So I don't know if anyone wants to talk about their particular points of view on what kind of information should go in and shouldn't go in. So Helen was saying nothing at one point, I think.
I don't think that we're not advocating putting those things in. I think, are you thinking particularly about, Helen, was it about possibly some of the signposting that was in Felicity's transcripts? Was that
well,
possibly?
I don't know. I think I definitely wasn't saying you shouldn't do that. And one of the nice things that what you're doing is researching different possibilities. And I guess what I was trying to do with that framework is make it possible to diverge, not just think transcription is just one thing, but consider different transcripts for different purposes. And especially with covert recordings, it's explicitly up to it's importantly up to the jury. I would not recommend in covert recordings putting in the pauses and the exclamation marks and so on, because that is bringing in the transcriber's interpretation, and the transcriber does not have all the information that's needed by the jury. So that's why in that particular case, because if we look at the framework and we go to purpose and we think, what is the purpose of this and how is that different from other purposes? That's where I was hoping that the framework would be quite useful. It might well be the case that in transcripts of interviews that we do want that level of interpretation, because they're overt recordings and their purpose is quite different. In fact, I had a question for Martha if I would be able to do that. Just to plug my own framework a little bit more, I'm not completely sure on the purpose of transcripts of police interviews. So the purpose of a transcript of a covert recording is to help people hear, and the purpose of the transcript of a court recording is to make an official record that probably nobody will look at, but if they want to, they can access it. How would you characterize the purpose of the transcript of a police interview in relation to those others?
Well, the Dutch criminal law system is very dependent on written documents, and the police transcripts, police reports are just one of those documents that make up the case file. So they are very important for the whole presentation of the evidence, and it's just one piece of evidence, and there's lots of knots in the case file. But in court, the case file is the most important source of information, and suspects don't even have to present themselves at trials. They can do it without the suspect, but they can't do it without the case file. So the police reports are a vital element in the case file and in the system. But I'd like to say something else about the previous topic about well, how are we going to proceed and what's the future of transcriptions, and that's so easy, so difficult to change the legal practice and to change our reliance on transcript. In the Netherlands, they are changing the laws at the moment. The laws of the criminal code of procedure, they're changing that. And one of the things that they want to develop is automatic transcription. And they're developing software at the moment to do this. And well, it isn't finished yet. And the code of procedure is also still in development. But I'm very interested in the thought behind that is obvious, that automatic transcription is not biased, it's objective, and it's complete.
Well, I even have a comment on that as the chair.
Shall I first finish my?
Yeah, go ahead. Go ahead.
But I don't think they are thinking about the consequences for the practice, because they will end up with a big mountain of transcripts, and they have to somehow have to be made manageable so that people don't have to take days to read it or to understand it. So I don't know. I was approached by people from the police who had read an article of mine to comment on it, and I said, well, I'm very interested in it, and I'm ready to think with you and to comment on it. But then they transferred the problem to another institute, or to an institute, a research institute, and they said, well, they will contact you about it, but I never heard of it. Heard about by him, but maybe they are. I'd like to be involved in this if they let me. But so this is the situation at the moment. Everybody is not happy with the transcription of the police at the moment, and so this is the alternative. But so that was my addition to how to change. You can change the law, but you can't very quickly change the practice as well.
Thank you, Marta. I'd love to talk with you about the automatic transcription another time outside the session, because I can see somebody has a raised hand. So
I think you should say something about it, Debbie, from a phonetics perspective, just very briefly, to alert people to the issues.
Yeah, I suppose one of the things that I wanted to point out as well is that it is quite minoritizing. So those automatic transcription systems are built on mainstream speech, and I sometimes use them just, for very low stakes purposes. And I always like to tell people the amount of speech that I transcribed for my PhD. I had a research assistant phonetically transcribed within 2 weeks. So something that took me about 1.5 years took the research assistant 2 weeks, but it was 15 years later. But where the system fell down was the interesting part, and it was really crucial detail. And yeah, those systems are not really based on minority languages or dialects. And so, there's some of the issues that I would urge people to think about, definitely. But I'd love to talk more with you about it sometime, Marta. And I
think that's something that we should all pick up on generally. I think automated transcription is a huge issue that we need to be talking about in this. Maybe not right now, but I think it's hugely important in the UK as well.
I also think the whole matter of digitizing the criminal process, I think it will be inevitable, and it will change. It will change all the working routines of the whole community of legal practitioners.
Maybe this is a topic for the next symposium.
Yeah.
So I can see a raised hand, which I think is Raymond, is the name on the screen. Do you have a question, Raymond? Hi.
Yes, it's in a way, I feel inspired by what I've heard today and what I've learned from forensic linguistics. A few of you know I'm not competent in this arena. I'm merely a psychologist. But one of the things I think is really important about today's findings and related findings is that, of course, the human weaknesses and biases that are revealed by the work in forensic linguistics should impact more on my arena and others, in the sense that, of course, a witness to a crime or a victim, they make their own transcription in their head. You know, what they remember is not exactly what happened. They suffer from the same biases as those who do transcribing do. And of course, when the product, whether it be a person speaking about what's happened or a transcription, good or poor, of what they've said, the listeners here in the UK, it would be in a criminal case jurors. I know in most countries do not have jurors, they have judges instead. But they are making their own transcripts of the transcript that the initial person has made. And I think your work deserves more widespread credibility in general, because it does reveal that even people trying to do their reasonable best are still like us, they're fallible. So I'm sorry if that's not a question, but I just feel everybody's saying, what can we do about it? Or maybe we can't do much about a lot of human failings. You know, I'm never going to run 100 meters in 10 seconds, however hard I try. And so maybe I've been inappropriate. I just one final thing that mostly in the UK, I've seen official transcriptions of video audio recordings that are also sent to me in a so-called expert witness role. And it's very rare that I can find any weakness in the transcript, the official transcript, compared to what I'm seeing or listening. But maybe that's only in the UK. Thank you for listening to me.
Thank you for that. I'm sure the panel members might have some comment. I know that Helen may, if we're thinking about the covert recordings, definitely. Would anybody else like to make some comment? Kate?
Well, firstly, Professor Bull, who is considerably underplaying his wide expertise in this entire area, may I just say. Thank you, Rose. Really nice to have you here. The point you make about how this is already, the version that's given at the interview is already a kind of filtered version of somebody else who's already created their own version of events, I think is really important. And trying to link, what we're looking at is simply the physical representation on a page, but this links very strongly with work on things like memory recall and so on, of where people have already filtered the version of events before they even tell it again in the interview. So I think, yeah, this links really strongly with all of that. We're actually hoping to link up with a colleague at Aston who works on memory. Things like that. So it's an area that I think, yeah, there's huge overlap, and I think it's a really important thing to look into. I don't know if Helen wants to pick up on some of the other things that you said there.
Well, yes, thank you very much for those very helpful comments. I think I want to somehow get to grips a little bit with the concept that when we're talking about people are biased, or the material is contaminated, or we can never get anything, there's always this sort of underlying sense that somewhere, somehow, there's the real thing, and we're all failing to get to it or falling short of that, and filtering and comes into that as well. I'd like to really promote the concept of priming a little bit above the concept of bias. Bias does come into it. That's when you're biased if you would like a certain outcome, and consciously or unconsciously you sort of warp things to fit that. Priming is rather different. Priming is essential. A lot of speech, one of the demos that I would have loved to have played, but I already knew at the beginning that I wouldn't have time for it. When we listen to speech with no priming at all, even if it's quite a clear recording, we just can't hear it. We don't hear anything. We need to have some understanding of the context in order to hear anything at all. So trying to wipe out all bias is not the right way to go about it, in my opinion. And I know that's relatively controversial thing, and we definitely don't want transcripts that have got all the information, as the Silk people have emphasized strongly. But we need to have transcripts that have got the information that's relevant to the purpose and the end user. Now, of course, we can say relatively simple things like there's no point putting detailed phonetic transcripts in if people can't read them. But I think we could push that a little bit further and say, what is it that they need to achieve with this, and what kind of transcript can we provide that will give them reliable assistance in achieving that, and leave as many decisions as possible up to the end user where we can.
We're sadly already running towards the end of time, and probably just got time for one more question. I can see Luna has a hand up. I think that's the only hand up at this point.
Hello.
Hi.
Hi, everyone. Thank you for a really great event. And I just had a very quick comment and a quick question. The transcripts in the UK have very large chunks of text missing. And sometimes when we look at them, there is something in brackets that says, and the conversation continues on this topic about X, Y, Z. And when we listen to the tapes, there's about half an hour of fascinating talk and expressions of empathy and all other things that are just not in the transcript at all. So I think that's what I found one of the major problems with transcripts in the UK context, that they're just so redacted. But I had a question about something that was going on in chat about the interpreting and the bilingual transcripts. And I wanted to ask the panel what your impression is about producing bilingual transcripts. We know they're very cost prohibitive, but they're really important quick reference. And there's been lots of research in forensic linguistics and forensic psychology about the differences and the problems and the need for cross-cultural mediation and all these issues in bilingual cases where we know that so much more is missing than in monolingual transcripts. Because of the costs, of course, we can't really afford that. The transcripts are bilingual in California, which is basically most of my data is from the US. They are always verbatim and bilingual. So I would like to ask the panel whether you had cases and whether you worked on cases, and whether there are experiences in other places other than the US where bilingual transcripts are produced and proven helpful in spite of the costs, maybe just for serious cases like murder inquiries or really serious crime. Thank you very much.
I can answer that quickly for the UK. Firstly, yeah, you're right. ROTEs are generally the edited version. So what we're trying to look at with the transcription experiments is separating that process out to look purely at the audio to written version. The editing process is another stage on top of that, which is very significant. But I think for both of your points, it comes back to purpose. So in terms of producing bilingual transcripts, it's generally not done in the UK because the purpose is to make this accessible as a piece of evidence. And the entire evidential team, so the police, the whole process, it works in English. So it's to render an interview given with somebody in a different language into a language which can be understood by the court and by the jury. So there's never, basically the ones I've always said, they don't represent the interpreted terms at all, because the whole purpose is to render the talk accessible to an English audience. It'd only be if there's a particular dispute about what was originally said, that you'd actually have transcripts of the original language of the interviewee. But I want to leave space for the others to say what goes on in their jurisdictions.
Well, in the Netherlands, the one police report I had with an interpreter excluded the words of the suspect and only reported the interpreter. So it's monolingual.
Yes, that would be quite normal here. There is a very large and important literature on interpreting police interviews. I don't know if Alex
including
Bowen
Luna's.
is still. Well, I was thinking in Australia. Sorry. Yes. And is Alex Bowen still there, or?
I can see him in the list of participants. Yeah.
Say something about that, Alex, if you wouldn't mind.
Yes, so there is a literature about interpreting in police interviews, and it maybe starts with some of the same simplistic expectations about what can be achieved and about how sort of transparently the interpreter will render all the meaning in the interview. But of course, it's not that simple, and there are a lot of interactional things that happen because you've got 3 people speaking instead of 2, and so turns have to be broken up, and people's narratives get broken up and all those sorts of things, and then meaning gets lost, and then which level of meaning are you trying to work with? Is it referential meaning or some other kind of pragmatic meaning, and so on. So it really complicates everything, and then in transcription that disappears to a significant extent. Is that what you had in mind, Helen?
Yes, I did. Exactly right. And especially the serious cases that we've had in Australia where translation in police interviews or interpreting has gone horribly wrong. And just to bring it back to my framework, I think we have to remember the role of the evaluator in translation and interpreting as well as in transcribing. If we have no record of what the original language was or what the translator interpreter made of it, there's no way for the other side to check whether that's been done correctly or not. That may not be a big issue in police interviews because, again, it has to come down to the purpose and the context that it's being used in. And maybe if they're using highly qualified translator interpreters, these aren't big issues. But I think the framework helps us go through what is likely to be or potentially going to be an issue and check off each thing. Are we able to evaluate the interpreting as well as we are, as well as we need to?
And examples come to mind from a case that Diana Eads worked on and then wrote about, where there was someone who wasn't a professional interpreter in the room, and the police was saying, you don't have to say anything if you don't want to. And this other person was saying, you should tell the truth to the police. And this didn't come out until much later on when someone listened back to it and checked what that person had said, but that wasn't considered sort of, there's no mechanism to capture that in the ordinary course of events, and they wouldn't have known that that person was contradicting what the police were saying.
Thank you. And it's really nice to have that example, familiar with the example as well. It's basically time to wrap up. We're just going to go over time a couple of minutes because Felicity Deemer, I'm just going to hand over to her to say some words on behalf of the whole panel and myself.
Thanks, Debbie. So I just wanted to, for 30 seconds, just go into a tiny bit more detail about the research topic that Emma briefly mentioned. Hopefully you can see this slide here. So we have a research topic live on Frontiers, which we'd love you and anyone you know who might be interested to contribute to. So there are 2 deadlines. There's the deadline for submission of abstracts, and then the deadline for submission to the slide for the main manuscript, say May for the abstract, September for the manuscript. It's a bit funny because the research topic sits within language sciences, but you can actually submit to either the Frontiers in Communication journal or the Frontiers in Psychology journal, depending on the best fit for your article that you'd like to submit. And there are fees, I should say, and that is dependent on which journal you submit to. Frontiers in Psychology has a very good impact factor, and so that factors into the fees. Frontiers in Communication is a newer publication, and so it doesn't yet have an impact factor, and so that has implications. But I want to say that although it has these open access fees, which differ according to which type of manuscript you submit, which there are vast numbers within Frontiers, as you can see, there is lots of help and support for you to, so Frontiers have an attitude where they would never want the fees to be a barrier to somebody publishing, and so there's basically lots and lots of ways for us to cover those fees, whether it's through the Frontiers system, through institutional memberships, through libraries, or potentially pots of money that we might have access to. So yeah, please, it would be fab if people could submit and join the conversation, which clearly this panel has shown is very rich. Thank you.
Thank you, Felicity, and thanks again to all of the speakers. Do I need to hand over to you, Tim? Did you want to say a few words to wrap up?
I'll just wrap up with a few words. So thank you very much indeed to all of our speakers. It's been a fantastic event. Yeah, really, really rich in content, and the sidebar's been plugging away with comments and thoughts, and we'd be delighted to hear from any of you about any of the thoughts you've had, and I'm sure that goes for all the panelists as well. And certainly, if your thoughts could be a contribution to the Frontiers piece, that would be even better. I just want to advertise our future events. We have an events page for future events at the Institute, and we run events most Thursday evenings in sort of what is our UK term time, so that's 4 to 6 on Thursday UK time. And our next event coming up is Chris Heffer's at Cardiff University, and he's got a recent book out on bullshit and bullshit in legal context, and he will be talking about that. On bullshit and bullshitters, I think is the title of his book. So I can say that word as often as I like, because I'm only talking about it, and he's going to talk about where people lie in legal process and untruthfulness in legal processes and how that figures. But also on the link I've just posted, there's all our future events, and you're very welcome to join us for all and any of them. They're all free and completely open, unless otherwise stated. At the moment, they're all free and completely open. The other thing to say is we after these events, we have an informal meeting space called Wonder. And Emma has posted the link to Wonder, which I shall repost in case it's disappeared up the list. So it allows you to speak much like a post-conference coffee room in groups of 2 or 3. You have a little icon that you can steer around the virtual space and meet up with people and leave one group and join another group and so on. So if you do have time and energy to join us for half an hour or so afterwards, we will be hanging out there for a little bit. And I think that was all my notices. I'm trying to think, what have I forgotten to say? No, I think that's about it. The Frontiers, the Wonder, and our next event. So thank you ever so much for everyone for coming along. It's been great to see so many of you here, and we hope to see you either on the other site or at our future events. Thank you very much. Bye-bye.
Hi, Felicity. There she is.
Hi. Sorry, the reason I've dived back in is I forgot to get the link for Wonder. So I was, but now I've realised, of course, the chat is missing on my, because I went out and came back in. Sorry.
No problem. Let me scroll up and see that. Scrolling through loads of
yeah.
Right, okay. I'm going to put it in the chat again.
Oh, thanks so much. Thank you.
My pleasure. Yeah.
Thanks for everything today, Maria. That was so good.
It was really fascinating. It was so, I wish we could have gone on for even longer.
Yeah, I know, it was a shame. It was one of those ones where we could have done with more time, but yeah, it was great. Thank you.
You're welcome.
I'll see you soon. Thanks.
Okay. Bye.
Bye.
Okay, I'm going to close the meeting now, everyone, if you're still in the meeting. Okay, so I'm just about to close it. Thank you very much for attending.